May I please, Your Lordship? Lordship, with the consent of the other side, my lord, I beg to mention item number 11 of the today's list, my lord.
What is it about?
I'm for the appellant, my lord. For the State, my lord.
Yes.
So we need some more time, my lord, for preparation, my lord.
Council, Mr. What's your good name?
As doctor.
As the your government standing council
Yes, my lord.
submit that he needs some more time to prepare and argue the appeal. List up to 2 weeks as print.
My lord, if possible, after 12 June, my lord, rather.
Up to 4 weeks.
My lord. Highly obliged.
May it please, Lordship? Lordship, in item number 20, 21, and 22, the council is from Mizoram. He is not able to come due to his medical issue.
You can argue why VC. What is the problem?
Actually, I am not in the case, Lordship.
All right. It is stated that when council representing the appellant is not available today because of personal difficulty. A request is made to adjourn the appeals. The other side has no objection. List up to 3 weeks.
Highly obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 26, Lordship.
26. Why?
Lordship, the affidavit is filed today and the petitioner is going to
Who has
file-
filed the affidavit?
Lordship, respondent.
You are for the respondent
Yes,
state.
Yes, Lordship.
Excise department is filed,
Excise
Lordship.
department.
And I am the petitioner. I'll file reply, Lordship.
All right. Affidavit on behalf of the respondent, excise department has been filed today and council for the petitioner pays for time to submit a counter there to list up to 3 weeks.
Highly obliged.
What is the PIL about? What is the prayer?
PIL is to Lordship about wine shop. They are in
Shifting
violation
of
the
wine
rule.
shop. Location of wine shop.
No, in violation of the rule, they are going to establish a wine shop in the.
So location,
Yes, yes,
that's
yes.
the issue of location. Yes. All right. Very well.
May it please see, my lordship. My lordship, with the consent of the other side, my lordship, I beg to mention item number 25 of the
25.
daily list, my lordship.
Why?
My lordship, we are going to file affidavit in reply today. So that may be take along with the petition next week, my lord.
And council MS, your good name, please.
AMSN, my lordship.
AMSN representing the appellant submits that affidavit in reply on behalf of the appellant is being filed today and thus the matter may be deferred for today, list up to 2 weeks.
Obliged, my lordship.
My please, Your Lordship. A recommendation, Lordship, yesterday, my lord, council appearing for the response number 7 and 8. He submitted an adjournment slip, my lord. Or be request made to me, my lord. I am if I want to the appellant, my lord. I given my consent, my lord.
Which matter, sir?
28, item number 28, my lord.
So you are for the respondent?
Now I am for appellant, my lord.
Okay.
I'm for,
The slip has been submitted by respondents council.
yes, I have given my
Res-
consent.
Respondents council has submitted a prayer for adjournment,
My lord,
requisition for adjournment. You are for the respondent.
No, no, I am for the appellant.
The appellant's council has no objection. List up to 4 weeks.
My lord, after 2 weeks, my lord. it will
After
be
2
disposable.
weeks. All right.
Because no affidavit filed by the respondent yet, my lord.
Okay. Okay. Pleadings be completed in the meantime.
May I please, Your Lordship? Lordship, I beg to mention for listening for fresh contempt petition.
Do it, get it listed on 16th.
Obliged.
Item number 1 of daily list for orders.
May I please, Your Lordship? Lordship, petitioner in person is left in some other court. Finally, pass over the matter for the time being.
All right.
Pass it for the time being.
Item number 2.
What is the status of service? Has been received back. No such person. You have to provide the fresh address. The notice issued to the respondent has been received back with a report that no such person resides at the given address. Thus, the counsel for the appellant to furnish present of the correct address of the respondent within 3 weeks from today, whereafter notice be issued to such respondent afresh.
Matter numbers 3 and 4.
On behalf of the state, we have filed the affidavit yesterday, Lord.
Okay, what is the PIL about?
And this is regarding changing the boundaries of the district. In fact, we are withdrawing some of the districts.
You are
And
changing the,
we have initially, we have created additional districts. We have now revoked those notifications and assimilated with the original one, merged with the original one.
what do you say?
I want to file lordship, reply lordship. In one case, lordship, the state has filed affidavit lordship.
But if they are saying the position has been restored and as it was, then what is the grievance remaining to the petitioner?
Lordship, we have to file reply lordship.
Just for the sake of it?
Lordship, right. Because lordship, in the 6 years ago, lordship, these districts were created lordship. In the meantime, lordship, development has occurred. lordship.
Affidavit, in which matter you filed the affidavit?
Item number 3, lordship.
Item 3,
And what about item number 4?
same affidavit will do.
Same affidavit.
Because the grounds are same.
All right. Affidavit has been filed in the lead matter being PL number 26, public so and so. Affidavit on behalf of the state has been filed in the lead matter so and so. Then an Advocate General submits that the same affidavit shall be adopted on behalf of the state in the connected writ petition number 23/23. Affidavit, is it the registry shall tag the affidavit with the record? Counsel representing the petitioner may file response thereto if so required. List up 4 weeks.
Highly obliged.
ठीक है. We are not passing any adverse orders. I know this has been placed before me. Otherwise also normally we don't pass adverse orders. Yes.
Matter number 5.
And in this case, on the last occasion, we were asked to serve the respondents 4 and 7, which we have. We have taken steps. There is also an IA for praying for an interim order. So this is, this pertains to, we have challenged the tender process. And if some interim protection is not granted, well, the whole matter. will come
Argue that can't be granted for the askance.
Malo.
That's what your lordship last time. The matter was also taken up by your lordship when interim order was also, your lordship says that this is only an academic, my lord. Academic, and your lordship just recollect that already we have started. The work is going on.
Work is going on.
Yes, yes.
That is,
Appeal is admitted. Your lordship will fix for hearing, my lord. Appeal is admitted by your lordship.
and,
There was no interim order.
my lord,
Yes.
that is precisely the reason, my lord, if some protection, or else your lordship will fix it immediately for hearing. my lord.
We can hear it today, you argue. There is no difficulty. For us, category of the case is immaterial. You've probably seen that. Argue.
Well.
All right.
No, we have to file a reply also. It's a.
And,
Appeal is admitted, your lordship. is admitted.
In appeal, what kind of reply is required, sir? Reply was there in the writ petition.
IA, my lord, today. That's why your
So
lordship.
IA is for interim relief.
I know.
He says that hear me finally.
Your lordship will fix
You
it.
can't have the cake and eat it too, na?
Correct. My
Yes.
lordship will fix a date of hearing, will argue this matter.
Today is not auspicious.
Not,
One more date in the meter of the senior council.
my lord, in that case, may I pray for a short date? my lord?
All right. The appeal has been admitted. The respondents are duly represented.
We
List
have
for
taken-
hearing.
We have taken steps, my lord. I don't know who has.
Let's check. Let's check. Why?
My junior
There's
has
some defect.
brought the tracking report. Apparently, sir, this shows that the service has been affected.
Issued, not returned back. Notices issued to the respondents numbers 4 and 7 have not been received back after service. Await return of notices for 2
My
weeks.
lord, my junior has collected the tracking report of the.
So you file them, file the tracking report on record.
My-
Registry will wait. We are just awaiting notices.
my lord, may I pray for a date? my lord? Short-
Await return of notices list on 25th May.
After, my lord, only one,
My lord,
after 1st of June, whichever is convenient.
3rd June.
Deeply obliged.
3rd June is a Saturday one.
All right.
In that case, can it be
2nd June.
2nd June? Second.
Second. IA is there, no? 1865. Okay, why the IA is probably in defect, Mr. Chaudhary? There's some defect in the IA. It has not been numbered. Check it out.
My lord,
Only one request, which subject to convenience of my lordship and my learned friend. Learned friend from some Kolkata, can it be on 5th of June? If it is not inconvenient, 5th of June.
Yes, it know.
Fifth.
Deeply obvious.
Item number 6.
May I please, your lordship,
Mhm.
there's a delay of 19 days, my lord, in filing of the appeal, my lord.
Who is there for the respondent? Mr. Das was there last date. Is he here? He has to be here. Only after hearing the other side can be gone on the delay. Pass over for the timing. Second round में लीजिएगा.
Item number 7.
My lord, this IA is for suspension of sentence, 12 years imprisonment in an NDPS case,
20 years.
12 years imprisonment,
12 or 20?
12, 1, 2.
12. Okay.
Only predicament is that I have to file my written objection. It has come up for the first time, I think, the IA. In the appeal orders. were passed.
Special additional public prosecutor, MS S. John praised for
One
and is
week's
granted
time- 1 week or 2
a week's time to file reply in the application for SOS. Reply oblique objection.
My lord, may I pray for a fixed date, my lord?
She shall also procure the criminal antecedent report, if any, of the appellant.
Lodge.
List on 25th May.
Lodge.
I'm so deeply obliged.
Item number 8.
This IA for my lord suspension of my lord.
Have you filed the objection?
Yes, it's on record.
All right. What is the matter about? Conviction under
Conviction under section 376 and section 4 of POCSO.
POCSO. All right. Have you pleaded the complainant as a party?
My lord, complainant as well as my lord, victim, my lord, 2 and 3, my lord.
They've been served.
No, my lord, on 2/5/23 notice.
Then the service has to be awaited. No? The learned public prosecutor shall instruct the investigating officer to inform oblique notify the complainant, the victim as well as the complainant.
My lord.
Response numbers 2 and 3 regarding the instant appeal as well as the application for SOS. The intimation shall also contain a note that in case the victim oblique complainant are not in a position to engage a counsel on their own, they shall be provided the services of a free legal aid counsel by the Assam State Legal Service Authority.
In respect of that service, there is of course a Supreme Court judgment that even in bail applications, the victim needs to be heard. But we have a notification of Guwahati High Court where it doesn't provide so.
Read the
Without
rules,
hearing-
madam, POCSO rules. There's a
Yes.
mandate. There's a Bombay High Court judgment. What is the age of the victim?
16 to 18 years.
16 to 18 years. But that is also my lord, contradictory
Yes, of course.
on the
but-
basis of a.
Because had it been less than 16, 437 capital A
Yes,
is a mandatory requirement. Get them served. They made them a party.
lot.
Get them served.
Yes,
Obliged.
obliged.
Rule is made returnable in 3 weeks.
Item number 9 and 10.
my lord, before my friend produces the record, the query that fell from your lordship with regard to the termination and the revocation, the day before yesterday, my lord, that matter pertaining to seniority in the transport department.
Mm.
My lord, my junior has done some digging. This issue was never really an issue before the learned single judge. Some new materials have come to light. We pray for a week's time to, my lord, file an additional affidavit so that we can bring these things on record.
Can you refresh the memory?
My lord,
Frankly
my
speaking,
lord, let me play. What had happened, my lord? The appellant before lordships, he was initially appointed under regulation 3F
Mhm.
in 1997, my lord.
That is ad hoc kind of appointment.
Ad hoc.
Yes.
Then, my lord, while he was having an ad hoc service, my lord, There was a criminal prosecution under the Prevention of Corruption Act.
A termination part, yes.
Now, what had
Now I
happened
recollect,
initially-
now I recollect, yes.
Initially, my lord, he was, my lord, on 31/3/97, he was placed under suspension.
Mm,
Then, my lord, on 8/9/97, his service was terminated. Ad hoc
That-
service,
all right.
yes.
Mm,
Then, my lord, on 9/2/2001,
mm,
the termination order was revoked with the condition that he will continue to be under suspension.
mm.
Then, my lord, 22/3/2001, suspension was revoked, and my lord, he was reinstated.
Can there be a reinstatement in ad hoc services?
No, my lord, my learned friend is laughing, but there is not a whisper in the writ petition. We are also taken by, my learned friend the other day made a submission that we have not said so many things. Where is the scope to say? What is your writ petition is all about? Neither in the affidavit in reply anything has been said.
Mm.
This is for the first time, my lord,
Mm.
in the appellate court, now they have brought out this issue. And with all respect, my lord, the learned single judge could not have taken note of that ground. Because it was nobody's case. Nobody even argued, my lord.
Mhm.
And we are also taken by surprise. That's why, my lord, in the writ petition, we have not been able to bring out anything. Now, my lord, yesterday, we have also brought out all the record. I'll say to Nadia.
So place it on record then, whatever you want to do.
My lord,
And
my
let
lord,
them-
regarding my learned friends
We'll,
there,
we'll give you liberty to examine the record.
yes,
You also, the record is here.
yes,
You also have a look at the record.
yes.
If
But
you
in
can-
fact, my lord, we have got all the papers, my lord.
Okay. So what is the status of, was there a formal order of termination?
No, there was, my lord, yes, there was. Order to close.
But Mr.
Can I-
Chaudhary,
My lord,
tell us the service jurisprudence. An employee in ad hoc services is terminated,
yes.
whether there can be a reinstatement.
My lord, that is of course an issue that is an issue which may perhaps be required to be gone into in an appropriate case. But can I just hand over this set of documents? Yes, never. Let us say,
Right.
because there was no pleading, that's why we were never, I mean, called upon to
All right,
answer.
you exchange, we'll give you the opportunity,
yes.
place everything on record.
If your lordship will kindly have the first document,
Hmm.
31/3, now Manoj Kumar Chaudhary, Enforcement Inspector, so-and-so, is hereby placed under suspension. The next order, my lord,
Hmm.
services of Manoj Chaudhary appointed by order as Enforcement Inspector under so-and-so and placed under so-and-so are hereby terminated. Basically, these are all because of pendency of criminal case. In the criminal case, he got a clear acquittal, my lord. Then third
Yes,
document,
okay.
department notification dated 3/9/97 regarding termination of service of Sri Manoj Kumar Chaudhary
There could not have
is
been
hereby
any,
cancelled.
there could not have been any continuity of service when the man was ad hoc, serving in ad hoc capacity.
No, my lord, for the,
That issue you have to address,
no, I'll address.
place on record all these
No,
things.
only thing is, my lord, since this issue was never brought before. the
Maybe now we'll examine, we'll permit the issue to be examined here. In appeal, that is a fundamental issue.
But it
It
is,
goes to the core of the matter.
No, my lord, my lord, whether in a writ appellate court, party can be for the first time permitted to bring
This
up record.
this is going to the root of the matter, sir. We just can't be ignorant of that.
Okay. Then, my lord, there is an order of, in this same very bunch, my lord, if your lordship will kindly come to page 7,
Hmm.
last page.
Hmm.
No, yes. Subject to discharge with the, no, this is not the order.
This is
Sorry,
the,
page 5, my lord.
Hmm.
The governor of Assam is pleased to drop the departmental proceeding drawn up against so-and-so
Hmm.
by exonerating him from the charges. His period of suspension is also treated as on duty for all the intent and purpose. So notionally, my lord, he'll continue to serve. He may not get pay for the period he did not serve, but his service will continue, my lord. It is not very uncommon in a
very-
service jurisprudence.
we have serious doubts on this. Ad hoc services, can these kinds of orders be passed?
But my lord, these orders were never challenged before any
That's right.
authority.
All right, you argue on that issue.
Yes.
Let them bring out whatever they want to file. Let them, Mr. Yes.
On last occasion, Lordship directed me that what is the original record, but I have listed the original record, my lord.
So all right, you keep the record with you. We'll consider the record if required on the next date. The MS Bora submits that the original record, service record of the appellant, has been received. Mr. Indranil Chaudhary, senior advocate representing the respondent number 1, praise warrant is granted a week's time to file an additional affidavit on behalf of such respondent. Permission, liberty is also granted to the appellant's counsel to file relevant documents if so required. Re-notify, the record shall be retained by MS Bora. List on, when do you want, sir?
After about 2 weeks, my lord.
After 2 weeks, date dal dijiye 2 weeks. 6 June.
Did done.
Right.
Item number 12,
No, in this case, we are aggrieved by the judgment pass, order passed on 5th of December, my lord. The compassionate appointment case, my lord. And we pray, let this matter be admitted, my lord. I'm not pressing for the stay at this stage, my lord.
What is the matter? Argue
Sir,
compassionate appointment, there is hardly any scope.
What has happened, my lord,
Argue.
is that the order.
Why
which
the
was
appeal
passed-
should be admitted for the asking?
The office memorandum which the learned single judge is relied upon, that is not applicable in the case of the appellant, my lord, because the appellant had applied prior to the notification.
Why you have been denied relief? Let us know first. Did not possess the educational qualification. And there is no vacancy available. These are the grounds. Argue, there are n number of Supreme Court judgments
My
now.
lord, what has happened, my lord,
Yes,
the office memorandum is not applicable in the case of the appellant, my lord, because the appellant.
sir, read para 4, no vacancy.
My
then what to
vacancies-
do?
And my lord, there are vacancies, my lord, which I can show from the, when the DLC had recommended the name of the appellant, my lord. That has, when the DLC had recommended, they were available post, my lord. That was not considered, my lord. And the first, when the SLC first rejected.
What
the-
do you say to this fact that you had applied for section assistant post and you are not having the requisite qualification?
No, the requisite qualification was also not applicable because the new office memorandum, it says about the qualification, my lord. Earlier, that was not there, my lord. And I'm a graduate, my lord. And I'm
Whatever.
also relying upon a judgment, my lord, passed by the another coordinate bench in the single judge, my lord, where at page 128, my lord, 127, my lord.
When did you file the application?
This application was filed, my father died on 11th of January 2013, my lord. And I-
13.
13.
And
I
you
had
filed the
applied-
application in 19.
No, 2016, 2013, I had filed, my lord, 11 to 2013.
All right.
Then the DLC met on 24/5/2016,
Mm.
after of almost 3 years. Then DLC recommended the name of the appellant, and on 31st December 2018, the SLC rejected, my lord.
Where is the rejection? Let us see.
SLC's rejection, my lord. First rejection. Is at page 105.
Mm.
This is the second rejection, my lord.
Yes.
Serial number 22.
But your first application says that the prayer was to appoint you, the applicant on grade 4. Then when was this prayer changed? Section assistant is grade 4 only.
Section is grade 3, my lord.
Then where was this, when was this change brought around?
What, my lord, may kindly peruse my application, my lord. I have said any other post,
Where is the application?
page 25, my lord,
Hmm. That is for grade 4.
grade 4. Then they recommended me for grade 3.
How could that have been done?
My
Where is the recommendation?
page 40 may kindly be seen, my lord.
There must be some change or of stand on your behalf. Only then they could have changed it.
And post applied for, I had written for grade 4, my lord, they gave in for grade 3, my lord. And my lord, at column number 11, this shows 26 numbers of vacant posts, my lord. So the posts were available, my lord. Then the first round of rejection, my lord,
Where is the rejection
first
order?
round, my lord, at page 45, serial number 80. It
Yes.
says 5% post already filled up, but that stand was again changed in the second round of rejection, my lord, at page 105. They said that I didn't have the requisite qualification, my lord.
Where is the scheme? All right, let us, where is the scheme for compassionate fund?
Scheme which the respondents are relying upon is the 1st of June 2015.
Hmm.
That scheme is not applicable, my lord, because there is a judgment passed by the court, my lord, that that scheme will not be applicable for persons who had applied prior to 2015, my lord.
Hmm.
I have that judgment, my lord. Two thousand 21 GLR 292, my lord. Paragraph 14 and 17, my lord.
All right, there are n number of judgments on that issue that this, whatever OMs are
And
issued are not retrospective in nature.
And my lord, the apex court judgment also says that when I had applied for.
The rules
scheme
which were
is
applicable,
At that point will be applicable and not subsequent OMs, my lord. Rules, my lord. And in
have you
a,
filed type copy of annexure 4? Have you please on record type copy of annexure 4, please? This is not legible. We want to know what caused the change in stand. You applied for class 4. Why you were considered under class 3?
I will, annexure 4 is at page 27, my lord.
We are not able to read it, sir.
I'll furnish a copy, my lord.
Counsel for the petitioner to file typed copy, typed oblique legible copy of annexure 4 on record. List of 2 weeks.
Number 13.
May it please your lordship. My lord, the challenge before your lordship is my lord, provision of subsection 4 of section 16 of my lord Central Goods and Service Tax Act. Because my lord, it takes away my entitlement given under section, my lord, subsection 2 of section 16 of my lord CGST Act. Your lordship may kindly first come to provisions, your lordship, that your lordship will find at page 9, my lord.
This matter is under consideration of various.
Various high court, my lord, Bombay High Court, Karnataka High Court, and my lord, Calcutta High Court, and Calcutta, all the high courts have been pleased to issue notice, your lordship. But here
Issue notice, Mr. KL puts in
but, my lord,
appearance.
no coercive measure, my lord, because they have issued.
This issue has already been decided by Supreme Court. Similar issues in 2019 lordship.
Let's see.
Similar issue lordship.
Let's see.
2019 13 SCC page 225.
Let's see.
And I have also decision, my lord, if my lord.
Decision of Supreme Court.
Supreme Court.
Let's see what judgment you are relying on.
My lord.
This is
Pass it on, please.
ALD Automotive Private Limited.
Three judgments, what is the citation?
2019 13 SCC page 225.
225.
Approximately.
What is the ratio? Please read.
A similar issue has been decided. Lordship may come to paragraph 43. The particular issue with regard to limitation or.
Claiming ITC
Yes, Lord.
limitation. Para?
Para 43, issue number 5. Actually, I'm holding another citation, Lord. Another book.
All right. Is SCC you are referring to, no?
Lord, citation is SCC.
Yes, we are having that.
Issue number 5, Lord.
Hmm.
Paragraph 43 in my.
Issue number 5, para 46.
Lords, one of the submission advanced by the learned counsel for the appellant was that the appellant SSC had valid explanation for not claiming input tax credit in the time provided under section 1911. Hence, the authority has jurisdiction to extend the time. It is submitted that the time period is contained in section 19.
We have already found that the expression shall occurring in 19.1. Where is 19.1 reproduced? Is it analogous to 16.4?
No, my lord.
Yes,
This is not.
yes,
very
Lordship.
Let's see.
Your lordship may kindly see sections. Then
Here, Lordship, what sale is there
There
in
is-
section 16.
there is no.
16.4.
there
Is
no-
it, is 19.4 reproduced in this?
There is with regard to Tamil Nadu Act, Lordship.
What we want to find out is whether the language of both provisions is identical.
That
19.1, then we have to read now. If you want us to apply this judgment, then you have to satisfy that both the provisions are
Sorry, material.
yes, Lord.
analogous to each other. Which judgment are you
In
relying?
fact, your lordship, honorable apex court.
Monday, I'll obtain that text. Lord.
Monday?
Yes, Lord.
All right.
This
Every on Monday.
decision says, my lord, ratio is this, my lord. By way of my lord, if there is no linkage, if I am entitled for, my lord, refund your lordship by incorporating certain provision, my lord, that entitlement cannot be takes away by my lord.
This is precisely what has been decided. Read the judgment.
My lord, here, my lord, three judge bench of honorable apex court held and Karnataka and my lord in other high court. My lord, if your lordship, my lord, doctrine of substantial compliance, your lordship will see. Here, your lordship, there are two elements of that, your lordship. One is, my lord, substance, another is essence. In the present case, my lord, we have, my lord, filed a return. Only because of technical glitches, it was not filed within time. My lord, my right entitlement cannot be takes away by my lord subsection.
Yes, all right, Monday. 15th.
DP of that.
Item number 14.
As prayed by Mr. Scale list on Monday.
May I please, your lordship, my lord, here, my lord, we have challenged the rule 5, 2 and 11 of Assam Cooperative Service Rule, my lord. There are
What is wrong in the rules, please?
a rule that 10% of vacancies to be filled up by the junior assistant as the junior inspector of the cooperative societies, my lord. Whereas in the direct recruitment, my lord, in the post of junior assistant, same qualification is required. Why not? There is a liberty and option. He can choose also that direct recruitment to the post of junior inspector or oblique auditor. But here 10% vacancy has been kept reserved for the junior assistant of officers of registrar of cooperative societies or some.
Yes, so that is what incentive they give to persons who are meritorious in the lower cadre. That is existing in all many sets of service rules.
Yes, my
What is
lord,
wrong
but here they have regular course of promotion also, my lord.
Yes.
Those junior assistant, they may be promoted to the post of senior assistant also, my lord.
Yes.
But why the 10% vacancies to be kept reserved for junior assistant to the post of junior inspector? The same qualification, everything is same. Earlier, of course, there is a junior assistant matriculation was the required qualification. Now same after amendment, my lord, they have also required graduate qualification.
Yes.
So my lord, same cadre, the cadre is different, but same qualification, they may opt for that junior inspector also in the direct recruitment, the initial.
It is an incentive provided for their experience while working.
Yes, it's totally different. It's a ministerial service.
All
my
right,
lord.
you file a reply. Mr.
Yes, my lord.
You notice,
Yes, my lord.
Mr. Standing Counsel, Mr. G. Bora appears on the respondent, cooperative department.
Yes, my lord.
Copy of the writ petition be provided to Mr. Barua. Who prays for and is granted 4 weeks time to file affidavit. In opposition.
Obliged.
Item number 15.
Made please, your lordship. This is a matrimonial appeal against an order of the learned family court below, your lordship, whereby the suit was dismissed ex parte. Even though the respondent appeared and entered her appearance to her engaged counsel, but she did not contest the case. But even thereafter, the learned court below did not grant a decree for annulment of the marriage on the ground that the marriage was not consummated. That was the ground.
Not consummated.
Not consummated. And she has admittedly accepted that the marriage was not consummated, and she is also not willing to continue with the marriage. In that regard, she had given an affidavit which I have annexed at page number 31. Only for 12 days she lived with the appellant. In spite of the willingness of the appellant, the marriage was not consummated. She left the home and thereafter she never returned back. That has been stated in the affidavit at page number 31. That is what is also stated in the plaint.
Our section 12 says not consummated owing to impotency. That is a ground probably given to the wife, not to the husband.
Both husband and wife. Both husband and
Wife can't be impotent.
Now there is the term impotency has been explained and defined to the extent that it is not only physical impotency, even mental impotency.
That would be termed as a frigidity, not impotency.
Or psychological, it may be due to psychological reasons.
Yes, that is right. But How does it, your case come within the purview of section 12? Let us know.
Because she has not consummated the marriage showing different reasons. That may be due to psychological, or that may be, there is not, she has not filed any case against me.
Admits, issue notice, steps for service be taken within 3 days. Sent for LCR.
I'm deeply obliged.
Item number 16,
This is a public interest litigation. But the petitioner before your lordship is a renowned doctor from Guwahati. And he also happens to be the principal assessor of the National Accreditation Board for Hospitals. During his career, one of the things that he has been fighting for, in fact, this has now become a rampant problem in the entire state. Fake doctors and quacks. And he has so far been able to identify this identical situation had arisen in Orissa. And ultimately, at the intervention of the Honorable High Court there, some semblance of sanity has returned.
Orissa and Bengal are home to they are actually the creators.
Here,
All those institutes which give those degrees, they are in Odisha and Bengal.
it has become such as.
Have you given any evidence in support? Have you given any evidence in support of this?
In fact, I have given several instances.
Okay.
26, in fact, he has been able to identify 26. Some were arrested because the law provides for only detention for only a year. And they come out and they go back to some other place and start practicing again. And they are posing a threat to Article 21 of the
All
citizen.
issue notice, Mr. R.K. The PSJ appears on behalf of respondent number 1,
And
2,
two, I think, Lordship, they have got some standing counsel, Lordship.
respondent number 1, 3,
Yes, Lordship.
1 and 3.
Yes.
Steps for service. You will be, who will be appearing on behalf of Medical and Health Assam?
I am appearing for my respondent 4, 6, 7, 8 and 10. For the health department.
4, 6, 7, 8 and 10. आप क्या लगाइए? And respondent number 4,
4,
sec-
6, 7, 8.
4 you are appearing.
Yes, ma'am.
Chief Secretary. Respondent number 5, Mr. So-and-so appears. Thus, steps for service upon the respondent number 2 be taken within 7 days, whereafter process be issued.
Two, we have, my junior tells me that he has already served the standing council.
There is a standing council for 2. Who is it? Tell us the name.
Mr. A. Bora. But he,
Name is not there. Perhaps you can call Mr. Ebora.
Respondent 9 will have to be served by registered court.
Steps for service of respondent number 9
My lord.
be taken within 3 days. Thereafter, process be issued to such respondent by registered AD post. Ebora का पता कर लीजिए. Fine.
like. Or do I?
item number 17,
My lord, as per the instruction of this client, my lord, I am going to withdraw, already relief is granted.
And counsel for the appellant submits that he has been instructed to withdraw the instant writ appeal as relief has been granted to the appellant. Accordingly, the instant writ appeal is disposed of as withdrawn.
Obliged.
item number 18,
May pleases you, Lordship. This appeal has filed your Lordship challenging the impugn order dated 9/1/2023, which I have
Yes.
annexed,
Against the order dated,
order dated 9/1/2023.
what is the order about?
I have annexed it, your Lordship. Page 22 to 26, your Lordship. In the motion itself, your Lordship, stage itself, the petition has dismissed on the grounds of showing that your Lordship,
What is the prayer in the
section
petition?
156(3) CRPC, your Lordship.
What is the prayer in the writ petition?
Here, your Lordship, the appellant, your Lordship, appellant is a widowed, your Lordship, widowed, and she
Madam, a
is
simple question. What is the prayer in the writ
prayer,
petition?
your Lordship, with petition is to expedite the investigation. Which,
So go to the trial court. Sakiri Vasu is the appropriate judgment in your favor.
your lordship.
Go to the magistrate, file an application.
Your lordship, that is your lordship, kindly considered it as a special case because
Why?
she is a widowed.
So what of that?
Age
The
of
law doesn't change for any person.
70
Law
years,
law is equal for every citizen of this country.
70 years old lady, and she is living in Rajasthan, your
So
lordship.
what?
Physically,
what-
she could not be able to present, your lordship.
The FIR will have to be investigated as per law. These are basically civil disputes you are pointing out. And if there is any forgery or
Yes, your
fraud,
lordship,
the
forgery
FIR has been registered. FIR has been registered.
registered.
It
your
will be taken
lordship.
to its logical conclusion. What has happened so far in the FIR?
Your lordship, no investigation has been.
Madam, you
pursued, your
call for the
lordship.
investigation. You are representing
That's the government.
or call for the factual report of this FIR.
Lordship,
Let us know on 16th.
lordship.
The government council MS so and so shall keep the factual report pertaining to FIR number 217/21 PS Paltan Bazaar available for the court's perusal on the next date.
Deeply
On
obliged.
18th May.
Deeply obliged.
Letter number 19.
उनको disconnect कर देना. Yes.
May it please the lordship. My lord, here in this case, lordship, the honorable single judge lordship dismissed the writ petition as saying that that matter is infractious. But the letter which was issued by the architect council lordship, which is continuing law because the petitioner should have to continue his course. They already.
Then file a review, sir.
Lordship.
File a review that it was wrongly declared to be infructuous. So what? That is the remedy, sir.
Lordship, with all respect, lordship, since the detailed order was passed stating that, but with all respect, lordship, I pray lordship, let this notice may be and this court may adjudicate the matter. This honorable court, lordship. I pray because
Did you notice? The courts will be taken within 7 days,
lordship,
whereupon process be issued. You want the service?
lordship,
Dusty service.
lordship, their council is CGSC is there, lordship will serve the copy. And
Copies. Yes, sir. Architect. Here. For the, all respondents,
lordship,
for both the respondents, copy of the AP provided. This up to you.
market.
Yes.
Letter number 23.
What is this PIL about?
The PLA regarding my lord, religious places, availability in the religious places of all over Assam. Initially,
Availability,
it was for only one district now.
availability of what?
Yeah, for
In-
filing affidavit, we have filed affidavit from 5 districts, another 5 is ready. Because as directed by your lordship, we have to.
We
file
understand what is the, what availability of what facilities?
Facilities,
All right, so
facilities in the religious places.
you'll be filing affidavit now.
We have filed already 5 districts and another 5 is ready to file and another we are filing.
They're not very clear, sir. You want to file affidavit on behalf of whom?
Deputy Commissioner from all districts.
All district.
All right, Leonard. Additional Senior Government Advocate, Mr. Bora. Praise for is granted. 4 weeks time to file
Yes, ma'am.
additional affidavit on behalf of Deputy Commissioners from all districts in state of Rajasthan. List of 4 weeks.
Deeply obliged.
Letter number 24.
Yeah, like earlier moved, I think, because from all the religious places, what are the percentages, they collected the data.
They have collected.
Then they did this.
Yes.
May it please your lordship. So in this matter, I'm appearing for the Assam Seed Corporation. Now, we are supposed to file an affidavit pertaining to 2 particular players within the PIL regarding what actions have been taken therein. Now, in this regard, lordship, I have a communication that we received from the managing director of the Seed Corporation.
Mm.
An inquiry has been initiated by the department, the agriculture department, for the entire aspect to be looked into, and thereafter probably the fixation of responsibility and accountability will come in. So
Mm.
my prayer before lordship is, if at least 3 weeks time is granted, the inquiry report will come And thereafter, I can file a proper affidavit, bringing in all those matters, Your Lordship. That is my request, Lord.
Mr. Kalita appearing for the respondents number 4 and 5.
I'm Mr. A. Sharma, Lordship.
Vishwadev Sharma appearing for the respondents numbers 4 and 5
Yes, Your Lord.
submits. Last date there was Mr. Kalita who was
He's
putting
my
in
associate.
appearance.
He's my associate, Lordship.
He's yours.
We have been newly engaged in this matter.
All right, submits that he has been instructed by the managing director of the Assam Seeds Corporation that an inquiry has been initiated pursuant to the registration of the instant PIL, and that he shall collate the informations collected during the course of inquiry and file a detailed affidavit within next 3 weeks.
3 weeks.
Time prayed for is allowed. List after 3 weeks.
Obliged, Your Lordship.
Matter number 27.
In this matter, Lordship, stand of respondent number 1 is very much required, Lordship. They have not filed affidavit.
Madam M. Bhattacharjee. Affidavit on behalf of the respondents numbers 1 and 2.
What who has filed? Who has filed?
Who has filed?
Lordship.
One, you require affidavit of
Chief Secretary's affidavit is
respondent number 1 has still not been filed. MS M. Bhattacharjee appearing on behalf of such respondent. Is granted further opportunity. He says that you have not filed on behalf of respondent number 1.
On
Once-
behalf of respondent number
Two
two
has
has
filed.
filed lordship, one and lordship.
One's affidavit is very much required.
Huh?
Chief Secretary.
Only respondent number 2 has filed.
Hilarious
it.
department
Do
lordship.
you don't require affidavit of respondent number 1? We can proceed without that.
Chief Secretary.
Lordship, if so required, lordship, I shall obtain instruction and that I'll file. 2 weeks time may kindly be.
Further
granted, Lord.
opportunity of 2 weeks to file affidavit on behalf of respondent number 1. 2 weeks.
Development.
Matter number 29.
But
You filed the affidavit,
for the departmental affidavit, I need 3 more days time.
3 more days.
3 more days.
Mr. Nath submits that he needs further opportunity of a week to file the affidavit. Last opportunity is being granted for this purpose. List on 22nd. I'll file 22nd. Yeah.
Matter number 30.
Yes.
Lordship, this was the application wherein we had said that this habeas corpus has been filed because section 7, the notice was issued, but rule 4 was not followed.
Followed. All
It
right.
was given to the female member, which the rule clearly states that it should.
What is the status of the man now?
He is
Retinue
he is in jail right now.
still in jail?
Yes.
All right. So what is your argument? Let us see.
Lordship, my argument is that from the very beginning, the rule 4 says how it has to be delivered actually. The rule 4 of the Bengal Public Demand Recovery Act 13 says that service on
Act there. Read the ground.
service on adult male member of certificate debtor's family, where the certificate debtor cannot be found and has no agent empower to accept services of the notices on his behalf. Services may be made on any adult male member of the family of the certificate debtor who is residing with him. So this rule actually, the notice was issued under the section 7. 7 it says actually Services of notice and copy of the certificate on certificate debtor. Where a certificate has been issued in the office of a certificate officer under section 4 or section 6, he shall cause to be served upon the certificate debtor in the prescribed manner. The prescribed manner is mentioned in rule 4. A notice in the prescribed form and a copy of the certificate. So our thing is that the primary facie of this case is that he was kept behind the bus without serving any notices actually, because here all the notices which has been served to his mother, and
If there is no male member in the family, then what happens?
Lordship,
Can the interpretation of law be so absurd that no meaning can be given there?
Lordship, in here actually what happened is that this family has got two units actually. He is a divorcee right now and he stays backside actually. He does not stay with his mother. So the concept which your Lordship had asked, if there is no male member or any female member, what to do? Yes, there is no, there was no male member also.
Yes.
So the thing is that in the rule which specifically says in this act is it has to be served because it is on the act of the Recovery Act of 1913 and no amendment has been done for this one actually. The rule 4 as of right now also it says it has to be served in an adult male member only. There is no question of any adult female member or any female member as of now itself. So my argument is that the primary facie this case, he should not have been arrested because the arrest memo is in page number 30. This was done by the certificate officer giving a direction to the Gitanagar police station on. There were two actually. One is B512/2020 cases and other one is something B19 or something. The thing is that he has just instructed the police stations to arrest him. But the thing is that if I go from the ABC of this case, the notice itself has not yet been served. So the arrest warrant is highly illegal.
Yes. Who's there?
I'm appearing for respondent 1. But in fact, it's a case of habeas corpus. Unless, my lord, the petitioner say that the detention is, my lord, unauthorized or illegal. Normally, your lordship will not issue the writ. Now, his only case is, my lord, he does not say that the procedure was not followed. What is, my lord, his case is that the notice was not served on any adult male member. Your lordship has rightly, my lord, put the question, my lord, in that case, since, my lord, there is no definition in respect of male or female, so we may take recourse, my lord, to the General Clauses Act. If your lordship comes to, my lord, section regarding gender, my lord.
Yes.
The General Clauses Act is very specific. If your lordship comes to section 13,
Yes.
gender and number, 13(1), words importing the masculine gender shall be taken to include females.
Yes.
And it is not the case, my lord, that the petitioner or the mother is not adult. And there is also an explanation, my lord, that the servant will not come within, my lord, that family. And it is also not that case, my lord, that the petitioner comes within the definition of that explanation. So, my lord, my humble submission, no case has been made out, my lord.
Lordship, in here in rule number 4, it is also been mentioned that explanation a servant is not a member. That is also true. But here this is the adult male member and this is not.
Gentlemen, read section 13. There is no definition given. Section 13 of the General Clauses Act is there.
Lordship,
Masculine gender shall be taken to include females.
well, but this act specifically, my lord says it has to be of a male
All right.
member.
Understood, sir.
And apart from this one, this is not the only cases where the Bagija officer has arrested anybody.
they have been issuing the notices to the male members only. Here it is
We
of the
put you
female
a
member.
question, is there any other male member in your family? So these proceedings will be frustrated because of that.
Here, actually, there is a male member, there was a male member and there is a male member, his younger brother.
Oh.
There is a male member, my lord.
Does he
It is
reside
not
in the
that-
same household?
Yeah. my
Does
lord.
he reside in the same household?
Yes, my lord.
Where is your
He
pleading? Read.
Uh,
Read your pleading, please.
in my pleading, that is not yet
Then,
mentioned. Because the thing is, I am contesting on the rule with the federal.
all right,
female
we have
member.
understood that. Anything else to say?
My lordship, I just wanted to say that he should be released and he should go through the proper process of the law. Serve him a notice.
Make
and
the
then-
payment, get out. That's the way out.
My lordship, to get the payment done, he has to come out from the jail. That's the two, the thing is that he has two loans actually. He at that time had gone to compromise of the personal loan.
Mm.
So the thing is that this party, since it is the rule number 4 was not read this one.
That
and
you
he-
already said. We'll consider that, sir.
And my lord, he has been from the 1st of February right now. 1st of
Yes.
February, and the thing is that this, even if it is a convicted one, where is no such order as a, it is only for a term of 6 months actually.
Yes, all right. After 6 months, he'll come out.
But there is no order for the jail term actually. It is just an order by the Bakijai officer
Mm.
to arrest the person. There is
So
no
all right,
order.
you go and contest that your order is uncertain in terms of the term of imprisonment. Contest. Go and contest.
Definitely, my lordship.
That's the
What
way
you
out.
say is true, but here what I'm contesting is this one.
Make a payment, get out. If you can make give an undertaking that you'll clear the loan within, say, 1 month, 2 months, we can grant you interim bail. Ask your client.
Lordship, I think it can be made. I think it, yes. Yes, my- because the thing is that this has to be paid and in even
Give an
no way,
undertaking, sir.
yeah. Lordship,
Who is giving the undertaking?
Lordship, the undertaking has to be given by his younger brother now,
Why? The affidavit has been sworn by the mother.
mother.
You are
Okay.
saying that the mother is not residing with him. Or he is not residing with the mother. Mother has sworn, filed the petition rather.
Yeah, mother also can give it. That is.
Give an
But I'm-
undertaking. We'll
My-
consider
my-
your prayer then.
Yeah, my lordship, that can be, if this line can be mentioned, and then I will talk with this one. It is that we will give an undertaking, if we
Yeah.
will give an undertaking, then this
Yeah.
loan will be cleared in a matter of 2 to 3 months, because it has to be closed and
File
move it.
File the undertaking, we'll consider. We have expressed ourselves. Tell your client, if any
Lordship-
undertaking of this sort is given,
Lordship, I will mention the undertaking by latest by Monday. It's
all right, list on 16th as great.
obliged.
Matter number 31 to 41.
Well, Lordship, in this batch of writ appeals, well, I on last occasion took time that so many appeals have been filed. Let me examine whether some grounds have been taken or our affidavit is required or not. Well, I have examined the appeals. But our affidavit already filed in the writ petition will cover.
We'll cover the
Lordship
things.
takes the case for hearing.
Is there for hearing only argue?
But today it has come under the column.
You have not understood till now. That for us, the category of the listing is immaterial. The case is here, pleadings are complete,
Lordship,
category is immaterial.
Lordship may kindly accommodate me for today. I'm led by the Advocate General in this case.
What do you say, sir?
For that matter, I have got no objection, my lord. If the lordship is kind enough for fixing a specific date, my lord.
Learned Counsel, Mr. Nath submits that he does not propose to file any pleadings in these appeals. Any further pleadings in these appeals. As the pleadings were already filed in the writ court. In view of the submissions so made, list all these writ appeals for final disposal at the admission stage on 8th June.
Well, I have some personal difficulties on that date, if your lordship.
What date do you want, sir?
The third week, my lord.
Third week, all right. 22nd June. Okay,
Must always.
okay.
Item number 42.
May I please?
Writ petition.
Malad, this matter pertains to a challenge to the provisions of the Assam Minor Mineral Concession Rules 2013. Malad, what had happened here was, a stone quarry was put to tender. I applied, my lord, and then I became the L1. Now, normally in such tender processes, the requisite permission under the mining plan, the CIA clearance, everything is procured by the department. And thereafter, my lord, the provision is that 45 days time is there when that is transferred to me and by making payments. Now, in this case, my lord, the department had done nothing. Only the site was identified, the requisite permissions were not sought for. So, my lord, a LOA was not issued to me, a provisional LOA was issued to me. I made the 10% payment. Normally, my lord, we have to make 25% payment, 10 upfront and 15% after, my lord, this process is over. And then the agreement is done. Thereafter, my lord, I approached the authorities. They wrote to the director mining. When, my lord, the mining plan was prepared, it came in July 2022. Now, after the mining plan was got, my lord, I went for the next step. That is, my lord, for getting the clearance of environmental impact. My lord, that is pending. In the meantime, what had happened, my lord, they have invoked the provisions of rule 37(3).
Well, I'm sorry, my lord, this matter was to be conducted by my senior. Due to some personal difficulty, he could not come, my lord. So, my lord, I pray, my lord, this matter be posted next week, my lord. There was some urgency, it was listed on our instance, my lord. But due to some difficulty, personal difficulty, my lord, some sickness, my lord.
What do you say?
Nothing.
Or request is to adjourn the matter on behalf of Mr.
P.N. Goswami. I am D. Gogoi, my lord. I pray on behalf of Mr. P.N. Goswami.
Mr. Gogoi appearing for Sri Goswami, praised for time. Yes, Sri Goswami is reportedly not available today.
Not available due to some personal problem.
List on. When do you want, sir?
My lord, any day,
Next week.
I'm here, my lord.
June. June.
My lord, in this case, there is a stay in operation, my lord. My lord, government exchequer is suffering. So, my lord,
You argue today, we are very much available.
His son.
No, my
was
lord,
not
his
feeling
son
well.
is sick, my lord. My
son
senior
is not
son is sick.
feeling well.
So that's the reason, my lord. My lord, any date in May, my lord.
25th May.
25th.
My lord, they had given an undertaking that will continue.
Yeah, that will continue.
The undertaking given by the respondent state authorities shall continue,
Much-
shall remain in currency.
Deeply obliged, my lord.
Item number 44 of supplementary list.
Please, my lord.
My lord, on lordship's instructions, my lord, we have filed the affidavit in detail, my lord.
Today,
No, it is on record, perhaps at the last occasion it was filed.
respond number 2.
My lord, I am for the University Grants Commission.
Yes, respond number 2 UGC.
Respondent number
Yes.
2, my lord.
Yes.
My lord, in this case, the issue, the tiny issue, my lord, is that.
Can I just place my application if my friend doesn't mind?
Yes, yes, ma'am.
Lord, this is IA 3705.
Yes.
And the reason we are before your lordships in this application, my lords, is now the background of the matter is not this, of course, concerns holding of examinations as far as open and distance learning courses are concerned outside the state of Sikkim. That is the main matter, my lords, or which is under appeal. Now, my lords, in the meanwhile, my lord, while the matter is pending, one particular student who is based in Pune, my lords, who has a disability, he approached, my lord, the Commissioner of Disabilities. And my lords, the order is passed at page 30 of my IA. It's the Chief Commissioner for Persons with Disabilities.
Yes.
The lordship will find at page 30, the complainant is the student Amol Dani, and we have made the respondents, my lords, through the registrar. Now, my lord, your lordship will just come to 31 from para 5.3, if I may read, my lord. During online hearing, respondent informed this court that it is bound by the judgment of Honorable Sikkim High Court, delivered in writ petition so-and-so, dated 3rd January 2020. That is the impugned judgment in the writ appeal.
whereby the Honorable High Court upheld the validity of Regulation 13 of UGC Regulations 2017. Respondent further informed that effect of the judgment is that respondent is bound to conduct examinations within the state of Sikkim only. Respondent has submitted that the judgment of Honorable Sikkim High Court has been challenged by writ appeal 154 of 2021. Next date is so and so. The fact that the respondent has challenged the judgment of Honorable Sikkim High Court establishes that the respondent intends to conduct examination at location outside state of Sikkim as well. This court is also inclined to take the similar view. One of the purposes of pursuing education programs through distance learning mode is to avoid challenges of overcoming geographical restrictions while appearing in examinations. Because of this reason, educational course through distance learning are mostly pursued by professionals for purpose of career progression. These reasons become more evident in the case of Divyangan who are restricted in overcoming geographical challenges because of their disability and lack of Divyangan friendly accessible infrastructure in the country.
Conduct the exam of one man.
Just one person we are seeking leave, without prejudice to my friends, whatever contentions are, those will be open in the appeal. This is a one-off, my lords, we are asking for a liberty.
It's a special case.
My lord, if
Visually impaired man.
no, but I understand, my lord. If lordship passes an order to hold one examination online or for some other method, if lordship suggests, my lord, then that can be done. But this cannot be a precedent.
Obviously, we'll make it clear that this will not be a precedent. And it will not have any
effects on the
prejudice on the outcome of the appeal.
Yes, my lord.
That will observe. That will observe. But what will be the
But
modality
if
of voting?
lordship passes that order, my lord, the writ appeal becomes infructuous, my lord.
No.
Because
It's not so simple.
kindly see the prayer in the writ petitions.
Yes.
In the writ petitions, they want to hold examinations outside the territorial jurisdiction of that particular university.
That is a general direction they have sought.
No,
Now here we are dealing with a particular case of a differently able person. So this is not a general direction we are giving. As an exception, we are giving.
yes, my lord, this may not be set as a precedent, number one. Number two, my lord, my respectful submission, my lord. This lordship's order or the order to be passed in the writ appeal, my lord, in my humble submission, my lord, that cannot dilute the, my lord, so far as the Supreme Court directions are
There is a
concerned.
question of diluting anything, sir. Now, you see, the situation has changed. Mr. Nair is arguing from Delhi. Everything is happening from a distance.
I bow down to your lordship's
What is the
observations, my
problem
lord.
now?
But the thing is that
Virtually,
our hands are tied because of one thing.
you will be holding examination from Sikkim. Only thing is the candidate will be at a different location. So the examination is not being held at a different location, which is the center which receives the information. That will be Sikkim.
But I'm not
Think of
getting-
it in that manner.
My lord, the student will be in his own place.
Yes, but
But
you are not,
where he will be
you are not
sitting.
creating a center there.
I understand.
You are providing him facility to use the internet and give the examination.
That has to be, even if your lordship passes an order to hold the examination or to allowing this particular petitioner to sit in Pune to appear in an examination to be held in Sikkim, then the university itself has to create that infrastructure there in Pune.
That's what we are asking you.
Yes,
That's
sir,
what
but so
the question
what-
was. How
what
the
we
university
will-
will do it?
Lord,
That's what
we
the
will
issue.
go, because it requires some minimum infrastructure like computer, internet, etc., my lord. We
And
will-
what about one more thing, sir? What about the sanctity of the examination? How
Lord,
how
they
will
can,
that?
there will be an invigilator if UGC wants to nominate an invigilator from any government university, college, their own person. We
Yes,
have absolutely
application-
no difficulties.
Just the application is by the Sikkim.
By the
Manipal.
university, my lords. By the appellant, the Sikkim Manipal University.
The candidate
Because-
has not moved any application.
There's a reason for that, my lord. The
What?
reason for that is, my lord, page 32, para 5.6 in the same order.
Onus has been cast on you.
Yes, my lord, because they say you go and move an appropriate application, and if you don't, then we will go report it to Parliament, etc. The onus has been cast on me, my lord. After all, that poor student has to come all the way to file an application. That itself would be onerous
University
on
will
him.
create, you have an observer, they will bear the expenses as an exception.
Yes, my lord, they can approach the Pune University and
Yes.
we will
They will,
nominate-
they will create all these infrastructure. You give them the guidance how it is to be done.
That
They
can
will
be-
work under
yes,
your
yes.
directions.
That can be done. That can-
Yes, but let the student not be required to travel unnecessarily to Sikkim all the way.
Yes, yes.
He's an impaired person. So, all right, take down the incident. Interlock. Affidavit on behalf of the respondent, UGC has been filed. The matter comes up for orders on interlock the application number so and so. Filed by the appellant, Sikkim Manipal University, seeking permission to conduct an online examination of a specially able, within bracket, visually impaired student named Amol Subhash Dani, who was admitted to the MBA within bracket finance distance education program in the year 2017. The said candidate filed a complaint on account of the fact that the distance education learning courses were discontinued under the directions of the UGC.
No, the course is not discontinued, not holding of examinations. outside the
Holding of
syllabus.
examinations beyond Sikkim has been discontinued under the directions of the UGC, the said candidate moved an application to the Court of Chief Commissioner for Persons with Disabilities within bracket Divyangjan, Ministry of under the which was registered as case number 13263/22.
13263/1040/2022.
/22. The said case came to be disposed of by the commissioner by the order dated 28/2022 with the following directions.
Was para 5.5 to 5.7.
Reproduce para 5.5 to 5.7. Learned Counsel Mr. Nair, representing the appellant university, urges that this is an exceptional situation because the university has been directed by the Chief Commissioner to make an attempt to seek an order for holding the examination of the applicant and the other Divyang candidates by the online process within bracket remote location. He submits that in order to ensure substantial justice to the specially able person, without entering into the merits of the case and without prejudice to the outcome of the appeal, as an exception, an order be passed that the university would make arrangements to conduct the examination, to provide appropriate facility to the candidate for holding his examination from a proper location at Pune with the UGC observer under the supervision of the UGC observer. Then at counsel, Mr. Gayan, representing the UGC, submits so and so submits that this order may prejudice, such an order may prejudice the outcome of the appeal because precisely the controversy which is placed before the court in the appeal is as to whether the university can hold examinations from locations beyond the Sikkim state. Suffice it to say that the application poses the issue regarding providing facility to a specially able person for attempting the examination of the course which he joined as a distance learning course way back in the year 2017 from his city, that is Pune. It cannot be denied that requiring such differently able person to travel to Sikkim would cause him grave hardship and would be against the letter and spirit of the so and so act, Persons with Disabilities Act so and so. Thus, as a special case and without prejudice to the outcome of the connected writ appeal, main writ appeal, and without creating a precedent, it is hereby directed that the appellant university shall be allowed to conduct an online examination for the candidate Mr. Amol Subhash Dani by creating the appropriate facilities at Pune. The UGC shall appoint an observer for the examination. The expenses whereof shall be borne by the university. The
I'm
process as directed above shall be completed within 30 days,
Very well, Moses. 30 days.
Yes,
30 days from today.
I'm
The
very
property application is disposed of.
deeply obliged.
my lord, for this particular exam only. Hereafter, my lord, because if it is not.
This
the
is his final exam, my lord. Assuming he passes, my lord.
Yes.
See, we'll cross that bridge when we reach it. We can't prejudge the things. And how can we foreclose? Supposing he fails, then what? We will
My
ask
lord,
him to come back.
My difficulty is, my lord, my hands are tied because of the regulations.
Understand, sir, understand. But this is, you see, what the UGC did when they started these courses.
No, that is what I'm trying to place before your lordship. This university, I am on record on affidavit. This university has flouted all the directions since its inception. I can show from the
That
record.
is a contentious
No.
issue, my lord.
If I saw all this, my lord, I believe lordship will reverse this order.
Okay.
Only because my
For
heart
the
goes with
timing,
that person.
Let us
because-
not go on those ceremonies.
Yes,
especially
yes, my lord.
Assume that he'll pass.
Yes.
Hope. Let's hope.
My best wishes, my lord. My
Yes.
best wishes.
I am grateful, my lord. Very deeply obliged.
Really, really.
Item number 1, passed over matter.
Please, Lordship. My lord, the basic issue is here, my lord, about non-application of section 41 CRPC in right directions. My lord, unesma judgments are there, but lordship it's now seen that numbers of my lord cases where my lord that power has been misused, and basically my lord Joginder's case says it is a chief cause of corruptions, my lord. My lord, my only humble prayer, my lord, that lordship kindly should look into the first order passed by the Honorable Court on 9/3/2022 for a moment.
9/3/22.
My lord.
Is it basically the prayer you are making is asking the state authorities to act as per law?
My lord. And now, lordship, the interesting thing is that, my lord, only just to assist lordship, there is direction given by that Director General of Standing Order that is issued by the government of Maharashtra. In the same line, my lord, in the light of Anesma judgment and my lord, Lalita.
Madam, have a look at this direction. If you can replicate it in the Assam.
Yes, this notification.
We think that would serve the purpose.
Yeah,
Seek
exactly.
instructions.
I shall see.
The petitioner has appearing in person has drawn the attention of the court to guidelines regarding compliance of the Supreme Court judgment in the case of Arnesh Kumar. Guidelines issued by the Director General Police Maharashtra for compliance of the directions given in the case of Arnesh Kumar versus State of VR so and so by Honorable Supreme Court in the case of so and so. Learned Government Counsel MS Bora praise for it is granted a week's time to complete his instructions and to explore whether similar guidelines can be issued in the state of Assam as well.
That will, I think, make a position uniform.
List. This is just, nothing is subjective satisfaction. Even if the guidelines are issued, police officers will continue to act in their own way.
With the real picture, real scenario.
It's a fact. List after one.
Anyway, lordship, we are trying our
Yes, yes, yeah. We appreciate your efforts.
My lord. Deeply okay.
Item number 6,
Deeply obliged. They come before the. And they do not.
Yes, that is the problem.
Please.
Delay condonation.
Yes, ma'am.
Any objection?
No, my lord, I am wrong. I do not have any objection.
Delay condone. The connected writ appeal to be numbered and shall be listed for admission after 1 week. Item number 6. Only the reasons set out in the application, Jermaine. ठीक है ना? You've got prepared a standard order. Yes.
Item numbers 45 to 57, ward head matters.
J Kamal was supposed to. J Kamal was supposed to make submission today.
Yes, Z come up.
Your Lordship, I'm appearing for Mr. Jet Kama, Your Lordship, 16 Council, Your Lordship. He's having a person difficulty, Your Lordship. He's coming on his way. He's on his way. He is coming, Your Lordship.
Till then you start.
I'm not prepared, Your Lordship.
Hey, you are hearing the matter. We'll not dismiss it because you didn't argue it properly. Don't worry.
No,
Argue, make an effort at least.
no, Your Lordship, I'm not prepared, Your Lordship. I have tried calling him, Your Lordship. I will again call him, Your Lordship. He's on his way, Your Lordship.
Okay, very good.
My apology, Your Lordship.
This is not fair. We are in the midst of the hearing.
Yes, Your Lordship.
Council are supposed to be present when the matter is called out.
Yes, Your Lordship. I understand, Your Lordship. I tried calling him, Your Lordship. He said that he's coming. He's on his way, Your Lordship. So I will.
How
again-
long will it take?
I will again call him, I will again call him, Your Lordship.
Go and find out. Who else remains for addressing? Ashring Warissa. Borgoin, he has already, most likely his address. 12 Carlos Sanos. Chivangshu Paul. His arguments remain, no?
Mr. Chaudhary from Delhi, he was supposed to come on Monday.
Ms. Chaudhary from Delhi. So he's not here.
Yes, ma'am. The junior was here.
And RH Khan is again Z.
Jet Kamar.
Z Kamar.
In it.
And represents Debashish Bhattacharjee,
Devashish Bhattacharjee, Mr. Chaudhary, Delhi.
again from Delhi.
He'll be representing 3 of them.
Babul Kemprai.
Babul.
No one has argued the case of Babul Kemprai. Yes. MRM Haloi, SM Devi, SR Begum, RP Kakati. No one has ever appeared. This will again be a difficulty. What do we do of this accused? Going to be. And Golon Dalopagu. So kya Dola Gopu?
Dorogopo is not a convict in this case, and I want.
That is two.
Maybe 2.
Okay. Babul Kampra is in this one.
Babul Kamra is in this matter. And Banlal Chana.
Vallan Chana is.
Mr. Kamar. I'll try to contact Mr. Kamar and ask.
Right. Oh, it called for the soft copy of the judgment. बढ़िया क्या थी? And find out evidence का भी soft copy है. पता करें. That will make it a lot easy.
Babul Kaprar, I know the council, I can inform them.
You know the council, please inform us.
Soft copy of
Judgment we have prepared.
judgment can be, but evidence, I don't think it will. Evidence part.
पता कर लीजिए. NIA कोर्ट से पता करें.
Because we want to quote certain. Through the evidence now, it will be. But also. कर दो ले आओ यार। It's okay, not an issue, not an issue.
Well, I apologize, my.
Yes, yes. बाद में कर देंगे.
बोलो ना सुबह बुलाई दियो
थोड़ी देर ऐसी बंद करना.
पेपर बुक दे दीबा
Believe that we can also so that is
my lord, to start with it, my lord, running from here and there, my lord, for paper book, I have separated paper book, taking the leaves out of it, my lord, for your lordship convenience. Because while finding the guilt of the accused, my lord, 32 witnesses has been taken into account, but not discussed. That of course merit. So I prepared that paper book for your lordship kind convenience.
Thank
to
you.
go through the.
Thank you. That's
Region. Asset movie. I have taken the extract, Manu. I'll give a copy to them for their clarification, if any verification also, Manu. So, Manu, in this case, 14 points has been given as a finding recapitulating the evidence on record, my lord.
Can
And
we
that-
read that first?
Yes, Manu. That is what I.
That is also you
Absolutely.
extracted. 157.
Yes, my lord. My lord, in the paper book, I have annexed it, my lord, in my
Yes.
second paper book, my lord.
Yes, yes.
Restructuring organic process. At page 157, my lord, of my paper book, my lord.
Actually, we'll have to read it from the judgment. It's very
Judgment, I have-
sketchy, very sketchy kind of
Oh,
copy.
oh.
Copy is bad. We'll read it from the original judgment. Don't worry. Para 160.
164, page 194, and my running page is 157, my lord. Paper book page is 1994, my lord.
We are having the original judgment only.
Yes, my lord. Your lordship can look into the original.
Yeah.
Of course, I could feel it, my lord.
Yes.
Does the facts and circumstances appearing against the accused from the evidence discussed herein above, which could not be second in cross-examination, can be recapitulated as under.
Mm.
First is that I agree with the finding only regarding one. That is first point that has been rightly dealt with it. I have got nothing to say. I agree and admit. At the relevant time, he was working as Deputy Director, Social Welfare Department, NCHAC, my lord, not Kachar Hills Autonomous District Council. Though he was posted as Deputy Director, Social Welfare Department, NSCA, yet he was also working as licensed officer of the council during the period of the governor's rule. That is not based on record. And no evidence at all to that. Rather, there are positive evidence that I was not working as licensed officer.
Okay.
Then he has allotted contract works for supply of material to some firms, registration of which were not even renewed beyond 31st March of the financial year 2008, my lord. That evidence, according to me, has been wrongly appreciated from the case record. Then, my lord, fourth, while awarding contract works, the financial rules were not followed. I have followed the prevailing financial rule of 1953, my lord. He took signature of the Secretary Minaret Club, Jagir Khan, on some papers after
giving him 15,000 and rupees 25,000 respectively for the club. In lieu that he got some paper signed from him in respect of the above. So for this finding, I'm just making a small comment. Mala. He is a hostile witness. His evidence hostility was drawn, my lord, to that 161 part, my lord. And that thing has been taken into account, not the cross-examination into account, my lord. Then while distributing the food items to Anganwadi workers center, the procedure was not being followed by him. And he has been specifically told the supervisors not to fill up the quantities of the food item given to the Anganwadi center and obtain the signature on the blank challans. Again, my lord, this is not based on records. Rather, there are positive evidence that everything was supplied. Some of the money receipts of the bills paid by him bears forced signature of the proprietor of the farm who have allegedly supplied the materials to the department. No evidence at all to prove that the accused prepared the forced bill or documents, my lord. The CDAC has recovered a few bill challan and work order from the unallotted areas of hard disk, the material object number 78 bearing serial number such, material object number 79 bearing serial number such, which was shown to have been seized from Mr. Phonica Swear, that is PW 25, as evident from the report, White Exhibit 306 at page 11 and 12. This report is a preliminary report, not a final and neither a conclusive report that has been taken into account, which according to the law is not permissible. He failed to give any plausible explanation as to how bills, challans, and work order finds place in the hard disk for his office computer. This shows his nexus with accused Mohit Huzai is A3 and Devashish Bhattacharjee is A13. So this, they try to show the nexus. And here just a comment, Mela, that the operator, the data operator who was the custodian of the computer, my lord, he was cited as a Santosh Kumar, who was cited as a witness serial number 45, my lord. He was not examined. He was withheld. So an adverse inference rather should be drawn under Evidence Act 114G, my lord. Then one note in the name of Mohit Huzai. Mohit Huzai addressed to the principal secretary NSC was retrieved from the hard disk of his computer. This shows his nexus with Mohit Huzai. This note was never produced and neither taken into account while giving the report, half-baked report, that is Exhibit 306, my lord. Bills of some SSG 11, sorry. Bills of some SSG were recovered from the hard disk to which supply orders have been given and payments have been made, but the SSG could not be traced out by the postman for which reasonable interference could be drawn that the bills were false. So in this, I'll say, my lord, that the debtors could not be delivered because they were incomplete address, and it was hurriedly prepared a note within 8 hours, I think. I'll take your lordship to the evidence. The postman has given a report, prepared a report, my lord. A sum of rupees 4 lakhs were recovered from his house and he failed to account for such position. When the police came to my house, they raided it, that some terrorist activities were there, my lord, but did not find anything. Only on opening one of my almirah, 4 lakhs were found. At the very outset, my lord, the police PW2 Bodo, my lord, I said that this money belongs to my mother. And mother makes a petition for Jimma before the trial court at the investigation stage. That was rejected, my lord. So the court took it view since I did not appeal or sought any revision of that order, my lord. So it has attended finally. But the facts remain, my lord, that 4 lakhs were neither produced before the court, neither exhibited, and neither anybody knows where is that money. Till now, it has not come on the record, my lord. Where did that 4 lakhs go, my lord? It has not been produced during the trial for exhibiting those notes, my lord. And that goes to show my conduct also, that immediately at the time of the raid, I did not take any other plea. Rather, I made the plea clear that my mother is the custodian and possessor of that money. I was simply retaining it for giving it for further land development use. So in that view, my conduct shows post-occurrence conduct, that immediately thereafter, I have told the police that this money does not belong to me, it belongs to my mother. and mother also claimed for that, my lord. Then, my lord, there was short supply of materials by the suppliers as evident from the version of PW 37. And while he informed accused, advised him to receive the materials, telling him the supply will be made later on. For that PSW 37, my lord, prior to the occurrence, this occurrence took place on the day when Mohit Huja came into the chair of the CEM, my lord. Before that January that, my lord, he was already transferred from the place of his posting. So after the date of conspiracy, the date of charge, the FIR, my lord, prior to that, he was already out of that Haflong division, my lord. So he cannot throw light on that, and his evidence, I'll definitely take your lordship to that. Then he has given, lastly, my lord, he has given exhibits such and such to PW 45, along with the bills were not of the proprietor of the concerned firm, and payments were not made by check. Why the payments were made by cash, my lord? It has come on evidence because at that time, the banking system at NC Hill was very horrendous and not in accordance with the banking transaction. So there was no impediment in making payment in cash, my lord. So these are the basis of which. Now, my lord, before opening my case, my lord, I'd like to make 2-3 things clear, my lord. In this case, my lord, there are 3 sets of accused. One is the terrorist part, which your lordship has already dealt with, arms dealer and all this. Second are 2 government officers before your lordship, though one has died, my lord, that Corona Bush, Soikia, my lord. And I am one of the officers. Then, my lord, these 2 officers were from 2 different departments. I belong from the social welfare department, wherein I was the deputy director, social welfare, and one Corona Soika, who was the executive engineer, come additional chief engineer. For PHE works, that money was siphoned off. And that 1 crore rupees, which is alleged to have been found from the possession of A2, my lord, that money, they say, my lord, in the charges, the 70 lakhs belongs to Corona Soikia has funded it, and 30 has been given by this RH Khan. But nothing is coming from there, my lord, no evidence to that. Just a conjecture story has been projected, my lord, because it was never translated into evidence in the court during the trial. So for that, my lord, now we have to deal with 32 witnesses, my lord. And I have made a chart, my lord, which I like to place it on my booklet. I'll submit it, my lord, for that. That out of the 32, my lord, 12 witnesses have not stated an iota of word or spoke anything about me. There is no whisper about me, my name, one. Sometimes name may not be said, my lord, but under circumstances, it can be brought into it. That circumstance is also not there. So for the 12s are concerned, I have made a chart, my lord, that is 10, 18, 19, 21, 24, 27, 28, 29, 30, 34, 70. So this will be a total rather 15 witnesses, my lord, who has got nothing to do with the case for which the evidence has been taken into account, my lord. Then there are social welfare department, my lord, only 5 witnesses has been taken into account. That is 18, 25, 30, 37, 45 and 100. Then again, that executive members of the council, my lord, 2 councils members has been examined. So far, I am concerned, my lord, 23 and 126. And police officials, my lord, 3 police officials, though the CIO has not been taken into account while dealing with my part of the evidence, my lord. They are PW2 and 147. Likewise, my lord, I have prepared a chart, and only 1 beneficiary has been examined in this case, PW 99. And the post office man is 141. So I'll take your lordship one by one to that aspect, my lord. So, my lord, first, before dealing with the matter, my lord, I'll say, my lord, that whether the first information of this case, which has been exhibited, my lord, at page 61, original paper book FIR, my lord, whether that can be treated as an FIR or not, first, my lord. Because on the basis of that, the whole case has been moving around, my lord. That was the first point of time they tried to say. But my submission will be, my lord, that it is the GD entry on the basis of which everything was done. Because FIR was subsequent to the GD entry. But what is the GD entry, my lord? Because sometimes the GD entry may be to take just a telephonic call. That cannot be taken as FIR, my lord. But if that phone call carries or gives a message that it is dealing with a cognizable and non-bailable offense, then definitely that will can be termed and treated as an
The law
FIR.
is much,
My lord.
no, there's much divergence on that view.
No, I'll just throwing light, my lord, how this case was investigated right from the beginning, my lord. Just dealing with the basic root of the case, my lord, because
Very well.
the FIR is the starting point, my lord.
Mm.
So I'll just throw some light, my lord, for your
Sure.
lordship,
Carry on.
kind understanding of the matter, my lord. That is at page 1, your lordship, if you see the format by the police which they registered it.
Mm.
So if your lordship will see the page 1, my lord, column 3, my lord. This general diary reference entry number is kept blank. Occurrence took place on 1/4/2009 at 4 p.m. and the FIR comes to be filed on 1/4/2009 at 10 p.m. That is a gap of 6. It took 6 hours to file the FIR and the occurrence place is only 8 kilometers. Your lordship will find it at column 5. The distance and from the PS to the occurrence 14 miles GS
They had
road.
to count on 1 crore rupees.
Yes, my lord, that's too much.
So that time,
Counting and all this took place, but 50,000 is still less, my lord. So what I am trying to impress from here, my lord, is this, my lord, that this FIR now, if we turn to exhibit 30, my lord, and page 3, my lord. It is regarding Bokhisto PS GD 1162 dated 1/4/2009. So regarding this, my lord, the 2 persons were found on 1/4/2009 at around 4 p.m. The vehicle Scorpio was spotted and accordingly the money was recovered with the pistol. So from here, the whole thing starts moving around, my lord. And if we take you to the evidence of PW2 and the PW2, 10 and 145, it will throw light that they had prior information. Police had prior information that a party will be coming today to Guwahati with a money to buy arms. So that's why it has been disclosing a commission of an offense. যিটো জাজমেন্টৰ কথাবিলাক দিন 107
Just be on this format. This is what is forwarded. There has to be one signature. That's what I'm saying.
is anyone having a certified copy of this formal FIR?
My formal FIR has been ultimately exhibited. First, they exhibited the photostat copy. Then the second one, it was brought into record subsequently after process. Yes, it
anyone
is on
having
the
a
record, my lord.
Copy of that?
Exhibit page 61, now, paper book, exhibit, paper book 1.
This what you are showing to us is not the
My lord.
original FIR.
This is the problem. Actually, we also going through it came to know. This is supplied by the court, my lord, paper book. This is the photostat that was exhibited. Subsequently, it was detected, my lord, that the original is missing. So they re-examined the witness, my lord. That page 61 is the original one.
Exhibit.
This one, paper book, volume 1 of exhibit, ma'am. আচ্ছা, এইখানে মুখের কোন নাই এখানে এর কম নাম দিয়ে আছে এটা কি নাম হবে তুমি নয় এটা নয় এটা নয় এটা সেকেন্ড টাইম হবে এটা
I think this is it. TGM. 24. TGM.
No, no. No, yeah. This is. In your copy, it's not there.
Yes.
my lord. Your lordship has got it at page 61. The original exhibit was exhibit 36, my lord. So same thing, but only it is the original one, my lord. Earlier, the photocopy was given, my lord. No,
Sometimes that assumes importance. Yes.
My lord, now I take your lordship to the evidence that has been taken into account.
Yes.
Yep. My lord, let us come to page 107, my lord. Original page of the paper book will be 1944, my lord.
107 of your
I have
your
given,
one.
I have given in my paper book, my lord, 107, my lord, running page. So that we don't have to run from here and there, my lord.
Yes.
Yes, my lord. The name appears R.H. Khan, A4, my lord, for para 128. Following
You're
prosecution,
reading the judgment.
judgment, the evidence that has been taken into account.
All right.
The why I'm bringing it, my lord, your lordship.
This is an extract of the judgment.
Yes,
you're
yes,
reading.
yes, absolutely.
No, no. 107
Yes, my lord.
from this.
No, there are two paper books, my lord. My two paper book, these are.
All right.
Idea, my lord.
Yes.
Paper book two, my lord.
RH Khan. Yes.
My original page of your paper book will be 1944.
ये देना, ये वाला
ये नहीं देगा था।
read it from the original judgment only. Yes.
Well, I take your lordship. Why I am reading, my lord, that simply the learned trial judge has quoted the evidence. No finding, nothing has been stated. Your lordship will see, my lord.
Read.
My lord, I read, my lord. PW2, Sondro Kanto Boro testified that on 1409, while he was working as the OC of Bokhisto PS, then additional SP Sukhdar Singh and additional SP B Raskwa came and reported that some of the DSD group are going to deliver money to the extremists at Jorabad. He then deputed SI Moijuddin Ahmed to go to Jorabad, who is returning who on returning deposited 1 crore and 2 pistol and other article after intercepting 2 vehicles, and accordingly he lodged formal FIR upon which Bokhisto PS case number such was registered. So this is the quoting, my lord. How it is related to me, what comes out from me, my lord, nothing is here, my lord. So this is after the FIR was lodged, 2 months thereafter, my lord, I was taken into custody because the message has come from Haflong that we are in lookout of this man, R.S. Khan. So they comes and raid my house and they arrest me, my lord, after 2 months.
Yes.
Prior to that, I have got nothing to do with this terrorist activities, my lord. So this is the FIR, my lord, which happens to be lodged before the OC Bokhisto on 1/4. PW2 further testified on 3509 IO Bikul Soikia, that is PW 145. A Bokhisto PS case informed him from Haflong that one Ridaul Hussain Khan, accused appellant before your lordship, also involved in the case and residing at Torun Nagar, and sought permission to pick him up for interrogation. Accordingly, he along with his staff went to our residence, went to your residence at Torun Nagar. I don't know. Went to his residence, ought to have been done. At Torun Nagar, and on such recovered rupees 4 lakhs of 500 denomination from a wooden almirah and seized the same white list exhibit 9 along with one Nokia Samsung headset in presence of witness Amjad Hussain. Amjad Hussain is elicited in his cross-examination that the accused stated that the amount of 4 lakhs belongs to his mother. Except this, nothing could be elicited in his cross-examination of these witnesses. The learned counsel of the accused during argument has submitted that the amount of 4 lakhs belonged to his mother of the accused, who deposited the same with him after mortgaging her landed property, and he has no connection with the case in hand. Whereas the learned special PP for Nia has submitted that the amount never belongs to the mother of the accused, It is further submitted that during the trial, Mrs. Nurbanu Khanam, alias Nurbanu Khatu, mother of the accused R.S. Khan, filed one petition number 281211 under 451 CRPC on 15/11/2011, seeking custody of the said amount. And after recording evidence and full hearing, this court did not accept the contention of the petitioner and was pleased to reject the same white order dated 27/2/2013 by holding that the amount so seized is not belonging to Mrs. Nurbanu Khatun, mother of accused R.H. Khan. Now the said order has attained finality, as the finding of this court has not been challenged by the accused, and as such the accused cannot contend that the amount belongs to his mother. Having gone through the record, we find faults in the submission of learned special PP. Since the order of this court dated 27/2/13 has been passed after due hearing of the parties and considering the materials on record, and since the order attained finality being not challenged, and since the position has never been changed even after completion of the trial, we are of the view that the contention so made by the learned counsel for the accused has got no force. So accordingly, my lord, it was taken into account, my lord. And now, my lord, this exhibit 9, whether this recovery has been properly brought into record or not. Facts remain that my mother claimed it by her own method. And now coming to the exhibit 9, by which the alleged thing was seized, my lord, not a single witness of the seizure list has been examined, my lord. Neither the money was ever produced before the court as material object, my lord.
That is not required.
My lord,
Judgment of Sahiram.
I
Honorable
think, my lord, it
Justice.
will be required because of the fact, my lord, the seizure has to be proved in accordance with law.
Read judgment of Sahiram versus State of Rajasthan,
State of
2022. Justice
I'll take
Lalit's judgment.
My lord,
We had taken a similar view in a narcotics matter in Rajasthan that was reversed.
narcotic-
State of Rajasthan versus Sahiram.
Sayyidam.
Reduction of muddamal not necessary.
Okay. My lord, that is regarding the drugs, my lord, things.
That is more important.
But things
in
might be
drugs,
different, my lord.
it's
But we are
always-
on the house search, my lord, without any warrant or anything as such, my lord. Anyway, I was named as an FIR, not FIR name accused, my lord, but definitely I was thought to be connected in the case, my lord. So a case registered on a cognizable offense, they can search it. But the method of proving it was not done, my lord. Neither any of the single witness has been registered, save and except the seizing officer.
Where
It
is
is
the
further
seizure memo?
my lord.
Where is the seizure memo?
My lord, that is exhibit 9, my lord, page 23, volume 1.
You have not presented it along with this one.
Oh, my lord, we could not bring it, my lord. We can do it.
Volume 1 exhibit.
Yes, my lord, exhibit file, my lord. Page 23, my lord, document number 11. If you agree with me, I might have.
Okay, yes.
So there are also overwriting, if your lordship will see the date of seizure, my lord. Anyway,
There's
so
no
none
one.
of the seizing witnesses from the neighborhood, my lord, who were present there, my lord.
Yes.
As per section 100 of the CRPC, my lord, independent witnesses, things have not come, my lord. And in any way, my lord, I have taken the plea at the very outset, my lord, that this money does not belong to
Belong to
me. It's not an afterthought ploy, my lord. That is what I'm trying to submit before your lordship. It is further submitted by the learned.
What is
counsel.
the finding of the trial court regarding this money?
Money is that, my lord, that since the mother has not carried
No,
forward.
no, what is the consequence of this money being found?
Nothing as such, my lord. I
What
do
is
not
the
know.
criminal,
No.
the element of criminality attached to this recovery?
That is what, nothing has been found, my lord. Nothing, no comment.
Read, carry on.
Then, my lord, is further submitted by the learned counsel for the accused that PW2 has admitted during cross-examination that when he recorded the statement of R.H. Khan accused appellant. After his taking into custody, no such incriminating material was found against him in any manner, especially as regards to his terrorist activity or unlawful activity. And as such, he was wrongly arrested on the date of the seizure list is overwritten as 30/5/2009. It is a fact that PW2 has admitted in cross what the learned counsel has submitted. It is also a fact that while PW2 has recorded the statement of accused, no such incriminating material found against him in any manner, especially as regard to his terrorist activities and or any unlawful activity. But the question remains as whether an accused will state before police that he has terrorist activity or unlawful activity. Can it be expected from an accused that he will state before police that there exists material incriminating against him? The answer is got to be emphatic no. That being so, the admission so made by PW2 will have no bearing upon the veracity of the prosecution case. My lord, which I will say, my lord, is not well founded in law, my lord, that I have to admit that means according to the trial judge. So next, my lord, the PW10 is taken another police, my lord.
You need to
Moizuddin,
go through PW10.
yes, my lord.
He is concerned with that recovery.
Recovery.
You are not bothered
Yeah.
with that recovery.
But just one line, what was the finding, since your lordship always asks that, my lord? The 131, one para your lordship will sign regarding PW10, my lord. One line he has written, nothing is elicited in his cross-examination by accused R.S. Khan. So why should I do the cross-examination when
He
there
didn't
nothing
state
has-
anything against you.
against you, my lord?
Yes.
So that's why, my lord, this finding will not be in consonance with the law, my lord. Then comes PW11, Pritish Kumar Saki, senior financial advisor, testified that Assam financial rule is applicable to all areas, including hill areas, and under Rule 268, the department is to prepare plan and estimate and design of initiating any civil work based on schedule of the rate. And after getting approval of the competent authority, the department has to accord formal administrative approval, the financial rules, financial sanction to work, and thereafter it has to float tender for fixing the rate and farm from the work through open advertisement. Thereafter, on receipt of the tender, the department has to prepare comparative statement, and from the statement, the lowest bidder has to be offered the job. He conferred PW Exhibit 39-2 Assam Financial Rule. The Learned Defense Council has submitted that in NC Hill, the NC Hill District Fund Rule 1953 is the financial rule of the district, which was made by the governor under paragraph 7 of the 6th schedule of the Constitution of India for management of the district fund. And financial rule is not applicable. The Learned Council has placed before us a copy of the district fund rules for perusal. Having gone through the same, it is found that it relates to the management of district fund. Nowhere it is said that except the same, no other rule will be applicable, whereas Assam financial rule is applicable to all over Assam, and there is no exclusion to the clause in it, since NC Hill is one of the district of Assam with all amplitude and plenitude, the same will be applicable to the hill. My lord, with all respect, PW11 evidence is taken. On this point, my lord, there are 5 other PWs, my lord, wherein it has come on light that what PW511 has said are not correct statement of facts, my lord. They are PW 23, 25, 30, 45. For just a testing sample, I'd like to draw your lordship attention to the evidence of PW 23, my lord. He is an executive member, my lord, Takadin. Evidence to be unknown. He could not pass anything. Line to the evidence. If your lordship will kindly come to PW 23, my lord. Pulen Dologapu, who was at that time the EC member, my lord. No, I don't move. Page 79, your lordship, of the first paper book, because it's not taken into page 79, I'll read your lordship. In our autonomous district only, district fund rule 1953 is applicable, and district fund rules include the financial rule of autonomous council in autonomous district of NHC. And there is a district planning board. In the said board, the CM is the chairman. So this witnesses say that 1953 autonomous district fund rule is applicable and not that rule which PW 11 was referring. PW 11 was referring PW 7 was referring to rule 1939, my lord. Because subsequently, when it was declared as an autonomous district council, my lord, then the governor was pleased to make the rule in 1953 under the 6th schedule. So by that means 1953 rules was made exclusively applicable to the hill districts, my lord, wherein the autonomous council exists, my lord. So this person was also Partip Kumar Saki was a person who belongs from the financial advisor, my lord, to the public enterprise department, sitting in Guwahati, my lord. And this Dola Kapoor and another witness 25, my lord. 95, page 131. 131. In NHC, the Assam financial rule is not applicable. I'm reading PW, my lord, 25, my lord. In NHC, the Assam financial rule is not applicable, and in NHC, the North Kasar Hill Fund Rule 1953 is applicable. So all these positive evidence which has been brought into record, my lord, has not taken into account. Only one evidence which is contrary to 5 witnesses' accounts, my lord, has not been discussed at all, neither dealt with it. Only that PW 11 has been dealt with it. What about all these evidence which exists on the records, my lord, has neither been said or discarded or taken into account, my lord. So this fact, my lord, is contrary to the evidence available on record, my lord. PW 11's evidence that financial rule 1939 was applicable. Again, my lord, another witness PW 45, my lord, at page 363. In an autonomous district, there is a district fund according to paragraph 7 of the 6th schedule of the Constitution of India, and district funds shall be credited all money received by the district. The district fund rules 1953 is affected from 53 and is applicable in the autonomous district of North Kachar Hill Autonomous Council, and this rule is called North Kachar Hills District Fund Rules 1953. And this rule is applicable regarding the implementation of various works of the NSC, including the Social Welfare Department. So it makes it amply clear, my lord, that the 1953 rule was applicable in the Autonomous District Hills Council and not the Assam Financial Rule of 1939. And by that, your lordship, the learned trial judge has not dealt with the other positive evidence appearing on the record, my lord. So that aspect deals with that financial part, my lord. Now PW 18, my lord, as I have said earlier, my lord, it has got nothing to do with me because of the fact that this Kamalesh Pandey was working as the manager of one Madhu Milan guest house, wherein Fojendra Hojai, that Modskimi and all this, they took shelter out there, my lord. So I have got nothing to do that, my lord, why it is taken into account. And if your lordship will see the language used by the learned trial judge is your, my lord, which rather should be other way, my lord. I'll show your lordship. Kamalesh Pandey testified that he is working as manager Madhu Milan Guest House, Borabazar, Kolkata, guest house registration number, sir. Shows your associates, Fojendra Hojai, how long stayed in room.
Which para you are reading?
I'm reading para 133, paper book page 1947. My running page 110, my lord.
Yes.
Without any discussion, my lord, he has already come to the learned trial judge, come to the conclusion that Fojendra Hojai is my associate, my lord. Kamalesh Pandey testified that he was working as manager of Madhu Milan Guest House, Barabazar, Kolkata. Exhibit 50 is the guest house register and serial number such entry dated 2/11/8 shows your associate Fuzendra Hozai of Haflong stayed in room number 30. Fuzendra of Haflong stayed in room number 803 from such at the pointing out memo prepared at Madhu Milan Guest House in his presence. So otherwise, I have got nothing to do, but since your lordship, the landed trial judge has used that your associate Fuzendra Hozai. Without
What is the pointing out memo?
the pointing out memo where they used to stay and the register, the name where
Who
it.
pointed out? Who
entry.
pointed? Who pointed out?
This man, PW 18, man. This exhibit 52 and 53. Exhibit 52 and 53 are the pointing out memo prepared at Madhu Milan Guest House.
Kamlesh doesn't name this accused, no?
No, nothing, man.
Why Kamlesh's evidence is relevant?
My lord,
Only because
nothing
Fuzendra
has been
Hozai
discussed.
stayed there. Only because Fuzendra Hozai stayed there.
Yes, Fuzendra Hozai, he stayed, my lord. What I have got to do, my lord.
Right.
My contention is that the judge, before coming to the conclusion, has already narrated the facts, my lord, that your associate,
Yes.
which he is not my associated, my lord.
Right.
Then I come to PW 19, Paragmani auditor. He was a journalist working in Newslight, and police intercepted the vehicle, recovered huge amount of cash with arms, ammunition, and they telecasted the news. So what I have got to do, my lord, beyond compassion, my lord, to understand.
Yes.
So likewise, PW 21, Sandra Sharma testified he's known Mohizuza and family touched one Sonalam Lama and all this thing. That's regarding Imdad Ali, Joyanto Ghosh, and thereafter a man was sent to packet him and then gave it to Joyanto Ghosh. So this accused appellant has nothing to do with so far Chandran Sharma is concerned. My. Then PW 23, of course, it has got to do something, man, that I will show my. Kulendra Dolakapu, an executive member of the DSAC, District Hill Autonomous Council, testified that he came to know about the activities of DSDJ, about demand of money and violent activity they took. During 2008, ASD and BJP alliance was in power. During one of the meeting, Dipolal Hozai, CM cited his ill health and resigned as CM, and Mohit Hozai was elected as CM. That is already dealt with. He went with Mohit Hozai to Kuala Lumpur in February, March 2009. At Kuala Lumpur, he met Niranjan Hozai. He stated that he gave statement under 164 and exhibit 56 is the statement. In cross-examination of this witness, nothing tangible could be elicited by accused R.H. Khan. The learned counsel for the accused has submitted that this witness also stated that in Dima House of District, fund rule is applicable and no other act of parliament or state legislature is applicable in the district council unless the governor of by notification does not under the provision of 6th schedule of the Constitution of India. This controversy has authored said by raised by the Honorable Supreme Court long back. In this is not properly applied, I'll show. Regional Provident Fund Commissioner versus Shillong City Bus Syndicate, AIR 1966, SC 1546, wherein the question before the Honorable Supreme Court was applicable of the Acts of Parliament to Khasi Hill Autonomous Council. In the light of the provision of the 6th schedule, Honorable Supreme Court there made a reference to the Constituent Assembly debate found in para 12 and 14 of the report, which may be usefully extracted below. Dr. Ambedkar, during the debates in the Constituent Assembly, stated in unequivocal terms that the other binding forces is that the laws made by Parliament and laws made by the legislature of Assam will automatically apply to this regional council and to the district council unless the governor thinks that they ought not to apply. In other words, the burden is upon the governor to show why the law which is made by the legislature of Assam or by Parliament should not apply. Generally, laws made by the legislature and the laws made by the Parliament will also applicable to this area. But just for a moment, I will pause here and would like to clarify the thing, my lord, how this judgment is not relevant in our case. Because this judgment deals with the Autonomous District Council, my lord, which is not constituted under the 6th schedule of the Constitution since 1950. It is on a different noting, not similar with the not Kachar Hills Autonomous District Council, my lord. NAC is there since 1950, my lord. not Kasar Hills, my lord, was in existence and was constituted in 1950, my lord. It is nothing to do with NSA. It is only to do with the Khasi District Council, my lord, which stands in a different footing, my lord. Then reading para 136.1. The eventual conclusion of the Honorable Supreme Court is available in para 16, which is quoted below, with the clarification that para 12A referred to therein pertains to the autonomous district or regional council in the state of Meghalaya. It would thus be clear that on constitution of the district or regional council, paragraph 19 ceases to operate and power of governor becomes conterminous and ceases to exist. Simultaneously, the power of the district or regional council becomes operational to make laws on subject covered in paragraph 3 of the 6th schedule. Proprio vigro paragraph 12A comes into the force by direct notification that any act of parliament should not be made applicable or made applicable with such modification and exception as may be specified in the said notification. In other words, until such notification is published by the president, all acts of parliament which are not occupied by a provision contained in paragraph 3 shall proprio vigro become operative in the area of the autonomous regions or district in the state of Meghalaya. My lord. So it was while dealing with the Meghalaya District Council, my lord, it was there. Here it is in 6th schedule. The council was formed in 1950, my lord. That has wrongly been applied. If your lordship will go through the whole judgment, probably the thing will be more clear, my lord. NC2, 60 deal constitution, I call it. Khasi Hill was not constituted, my lord, under the provision of the 6th schedule, my lord. 6th schedule has got a special place. I did not say, my lord, your lordship knows it, my
No, please carry on.
my lord. So I'll not throw much light, but now coming to the concluding part, my lord, how he has taken that into account, my lord, at 136.2. In the case in hand, there is no such notification from any quarter to exclude the operation of the financial rule of the district NC Hill, and as such, by no stretch of imagination, it can be said that the Assam financial rule is not applicable to district. But there is also no such notification has been brought, my lord. If you read into the contrary other side of the coin, my lord, that they have also not produced any notification that this rule is applicable and that is not applicable. Rather, there are positive evidence from 5 witnesses, my lord.
What difference does it make?
My lord, that is while dealing with the monetary transaction part. The learned
Procedure which is to be followed would be.
Yes.
As per the.
Yes. That was not followed to siphon off the money, to misappropriate the money. But we say that we have done all this as per the rules of 1953, which was prevailing at that time. Nothing of that rule was violated because that rules provide different aspect. And we followed this different aspect. And we followed the spirit of the 1953 rules aspect.
Okay, very well.
So one PW 24, again, he is no way connected or relevant. Your lordship has already read his evidence. Amitabh Sinha, who was at that time the SP of NC Hills, my lord.
Yes.
That was regarding the recovery of some other cases, arms, my lord. So which I have got nothing to do, my lord. PW 25 is the star witness of the prosecution, my lord. She was not declared hostile also, though she spoke in the chief itself, my lord, against the prosecution, my lord. In spite of that, surprisingly, it was not declared. Subsequently, the NIA becomes wiser, my lord. Later on, they started declaring hostile. Till here, PW 25, my lord, it was in her own chief, my lord, she admits certain things which are in accordance with law. Mr. Accused appellant has done it, my lord. PW 25, Fionica Swear, Supervisor Jotinga Valley, Project Mohu and in charge CDPO of New Sangbar ICDC project testified that Exhibit 62 is a file number such and belongs to the Social Welfare Department. And the same contains bill and other receipt containing several signatures of R.H. Khan as Deputy Director, and she is acquainted with the same. So all these bills have been exhibited only by showing that this signature belongs to the accused appellant. Nothing beyond that, my lord. I'll show the evidence, my lord. Similarly, Exhibit 69 is another file on the subject receipt payment voucher bearing such, and the voucher therein bears his signature as Deputy Director. Exhibit 72 is the file of the subject voucher with effect from 1/7/2007 to 34/2009. And the same contains the signature of R.H. Khan on several pages. Exhibit 73 is the file on the subject rehabilitation of BPL person under ICD project area bearing number cert. And the same bears several signature of R.S. Khan as deputy director and vice Caesar member cert. One file number Iman was seized by NIA. Her further evidence revealed that exhibit 64 is the Caesar list dated. This is important, my lord, by which Western Digital made hard disk, Seagate made hard disk, and were collected by NIA officer, and she was asked to put the signature as a witness to the document, my lord. This evidence runs contrary to the evidence that is taken into account. And why I am saying, my lord, why I am saying this is important, my lord, because this hard disk was the thing which had been retrieved. Nowadays, deleted thing can be retrieved by the laboratories or by any other gadgets, my lord. So that exercise was carried out at Trivandrum, Kerala, my lord, where there is an expert institute, my lord, CDEC, they call it, my lord. That is, I have written the full name, my lord. For Development of Advanced Computing Institute, my lord. So it's that exercise was carried out there, my lord. They have given reports, my lord, what were the documents retrieved. But preliminary report was given, my lord, not final, and neither conclusive report was given. And from there also nothing is coming in the preliminary report. So this now Caesar itself, the witness, the NIA says that it was seized from PW 25, and the Caesar is also mentioned. But when she comes to the witness docs, my lord, she said that nothing was seized. I was asked to come to the circuit house or guest house in circuit house in Haflong, and the NIA said you sign it here. I accordingly signed it. And she was never a staff of that office. On the contrary, my lord, the person who was the custodian of that computer, my lord, though he was listed as a Caesar witness, my lord, in the charge sheet, my lord, as exhibit 25, and whose signature also appeared in this Caesar list, my lord, he has not been called in the dock to stand and testify this aspect. So in one way, they are withholding the material evidence to come, my lord, because there were contrary evidence. He was a cited witness, but he was not examined. Why, my lord? He was never called also. So this exhibit, your lordship can see it, my lord, from exhibit 64. Volume 2, madam. Volume 2 of the exhibit. Page 282, my lord.
Exhibit 62.
64 exhibit, my lord. Page number 282, my lord. This is the that Caesar list by which all these things are supposed to be seized from PW 25 Messrs. Pionica swear, my lord. Your lordship will see in the third column, my lord, from whom seized. It is that name, my lord, will come. Mrs. Pionica swear. This is PW 25, my lord. And from whom seized is there. Now, what is the evidence, my lord? And if your lordship will just turn the page, my lord, horizontally, we'll see that one name, Santosh Kumar Chaudhary. I'm not saying the other witnesses, but this Santosh Kumar Chaudhary, in the down it is written there clearly, my lord, data entry operator, office of the deputy director of that, my lord. It has got cut here. Originally, your lordship can kindly verify it, my lord.
Here are you reading Santosh Kumar Chaudhary from?
My lord, just if your lordship will take it vertically, my lord. Down below, my lord. Left side down.
Page 283.
No, 282 itself, my lord. At the bottom left, my lord.
Right. From whom seized?
Yes.
On witnesses.
No, witnesses. Caesar witnesses.
El Zobi.
Yes.
And
PW 141.
She is PW 141. And the second one is Santosh Kumar Chaudhary.
Yes.
Data entry operator. He was the custodian at that time of that computer, my lord, that hard disk from where it was retrieved.
He was not examined.
Not examined, my lord. He was the best person to throw light what and how the things has come, my lord. I'll just read a few lines from 25, my lord. Page 91. I have not handed over the file bearing such and such white exhibit 63, which I have read, your lordship. During the period I was in charge of CDBO Sangbar. I was not at the staff of the office of the Deputy Director Social Welfare. I was asked to put my signature white exhibit 3 by Nia. Nia, as I was called to the circuit house Haflong in the evening, and he had shown that exhibit 63 in front of me. And according to his direction, I signed the exhibit 63 by 1. At that time of taking my signature, no witness was present. I do not know the witness personally of exhibit 3. The file bearing number thus is the office file of Deputy Director Social Welfare, Haflong, and I am not related to this file, and I have not got no knowledge of the file. I have not handed over the seized material by serial number 1 to the exhibit 64, Western Region Sub. And this witness was not declared hostile. Probably the conducting prosecution thought that everything will get washed away if the hostile is declared. With all respect, it is not as such, my lord, because hostile can be declared for that very particular point. At this point, we are declaring him as a hostile. Rest of the evidence will stand, my lord. But nothing was done as such, my lord. Her evidence further reveals that exhibit 64, I have shown it, my lord, it was never seized, but it is said that it was seized from her and she has given those things to the Nia. Her evidence further revealed 138 para 2, my lord. Is a specimen signature writing of Puranas Bhora 12 pages, signatures of rehabilitation and such. My lord, it doesn't connect me, my lord, in any manner, my lord. These are all official duty. In discharge of official duty, all these are done. Cross-examination of this witness revealed that she has not handed over the hard disk and other materials to Nia, and no witness was present at the time of signing, which I have read it, my lord, by her, and she signed on the same at the circuit house. It is also elicited that as part of bills and receipt in the file exhibit 62, the delivery challan signed by the supervisor concerned shows that the materials are fully received by the concerned Anganwadi centers and the work for supply order was properly executed. Because the money that was meant for Anganwadi workers, self-group help, all this is said to be siphoned up and paid to Mohit. And Mohit in turn used to finance the DSD group. There is totally missing link. There is nothing to connect this fact, my lord. It is also elicited from the North Kachar Hill district, presently known as Dima Hassan, is an autonomous district under the provision of 6th schedule of the Constitution of India, and no act of parliament or legislative sale shall apply to such area unless the governor by public notification so direct. As an autonomous district, the North Kachar Hills Autonomous District, there is a district fund in accordance with para 7 of the 6th schedule of the Constitution of India, and district funds shall be credited all money received respectively by the district council. There is a district fund rule 1953, which is applicable in autonomous district of North Kachar Hill, which I have read, my lord, and implementation of various hill district, including social welfare department. Every list of beneficiaries of every scheme of social welfare department, welfare department, thereafter all scheme are executed, performed by the concerned CDPO supervisor, Anganwadi worker, helper, and every district department fund to the beneficiaries are done in public meeting in presence of the principal secretary of the council, CM, autonomous council, local MLA, Gaumburas, social worker, etc. It is also elicited in the cross-examination that exhibit 71 is the cash book. Number 3 is a cash book for the scheme of vocational training and rehabilitation center, Maibong, and TSC Haflong are under Women Welfare Scheme. Social Welfare Department Haflong maintains many cash book of different schemes. There is no number 10 main cash book in the office of the Social Welfare Department, and in main cash book number 10 includes the scheme of district and subordinate schemes, child welfare, welfare agent, inform, voluntarily welfare organization, other programs, other expenditure, and the cash book number 10 is not produced before the court. There is another cash book bearing cash book number 9 for the state priority scheme, and the state cash book is not produced before the court. For nutrition scheme, a cash book has been maintained separately, which is known as SNT cash book, and the same is not produced in the court. The cash book always reflects the actual receipt and expenditure of a particular scheme. When the office of the Social Welfare Department Haflong obtain a fund, and the state office may deposit the fund in their account, or the state office may direct the concerned treasury, and the concerned treasury office accordingly send to the bank to convert the fund into DCR. Instead of depositing the fund in their account, but when DCR open, it reflects in the cash book of the related scheme. So the bank statement cannot reveal the actual receipt and expenditure of a particular scheme, but the cash book concerned of the scheme, which will always reflect the actual expenditures and so these cash books were never brought into the court, my lord, to show that whether there was actual transaction or not, my lord. I think, my lord, it will be better if I read the evidence of PW 25 as a whole. But this is PW 25 was dealt with, my lord. Now coming to the finding part at 138, para 8, my lord, at page 1952, my running page 115, my lord. Thus, what it transpired from the evidence of this witness, the finding part, my lord, is that she was the CDPO in charge of New Sangbar ICDS project at New Sangbar in the year 2009. And in that capacity, she was supervising the official works, monthly progress report of the project, attending official meeting, field visit, distribution of foodstuff, official material to Anganwadi center, received from headquarters along with the supervisor. Except that she has no other works. In view of the admission, her evidence that during the period 2007 to 9, after verifying the related files of all the works of the scheme under Social Welfare Department, Haflong, it is found that the works were properly implemented as per norms and there is no any misuse of fund during the said period becomes one unworthy of credence. Why? She is not the authorized person to certify this. It's the PW prosecution witness, my lord, not my witness.
Right.
The manner she has deposed in her examination in chief and also in the cross shows that she is not of a wholly reliable. If I am not wholly, this witness was wholly reliable, my lord, then what is the other half which is reliable? That has not been taken into account. And as your lordship knows it, that it is the court duty to separate the grain from the chaff, my lord. So that is also not done. Just by writing a sweeping comments, my lord, it will not wash away the positive evidence of PW 25. Rather, it is their witness. No hostility was shown to the prosecution. So she was never declared as a hostile in any of the points. So that being so, my lord, the whole evidence is to be read as a whole. It cannot be taken as a tidbits or part-wise, my lord. So this finding of the learned trial judge, I think, will not be in accordance with law. And this learned trial judge, with all respect, my lord, he has taken the facts that has been come into file, but not the evidence on oath. Because your lordship knows that is the substantive evidence when the person comes in the dock and take it on oath, my lord, and speaks for the prosecution or before the court, my lord. So that evidence was not taken into whole into account, my lord. How that was separated is not coming out, my lord. Now, next witness is PW 27, Hiteswar Medi, my lord. This relates to the Public Health Engineering Department, my lord, which I have got nothing to do. I don't know why it is taken into account, my lord. PW 27. It testified that he was working as the consulting editor of any TV, my lord. He was a TV, my lord. And Niranjan Hojai, DSD chief, in the video clipping was supplied to NIA. Materials Exhibit 15 is the said CD contains the voice of Niranjan Hojai. Again, news of Hojendra Hosai and Babul Kampre was telecast. So voice sample it was taken, sorry, my lord, not PHE. He was TV, my lord. News reporter, and the voice samples were collected through that methodology, my lord. So I have got nothing to do with 27. Similarly, again coming to PW 28, Diganto Vikram Gayan testified that being the architect, my lord, he prepared some DPR, my lord. I have got nothing to do, and it was regarding the tourism purpose, my lord. Tourism department, CA, executive EM member has given it, executive member has given to draw. So that way, it has nothing to do with Social Welfare Department. Then PW 29, my lord, George Lamthanga, my lord, which your lordship has been taken time and again, my lord. That approval, my lord, who converted the dollars, my lord. I have got nothing to do. If your lordship wants, I can read it, my. I read, my lord, approval, my lord, because my name doesn't surface anything. I have
To your name at any place.
nothing, my lord. I have got nothing to do.
Absolutely.
The prosecution has to establish first, my lord, that I have misappropriated money, siphoned of the money, and given it for a terrorist purpose through someone. There is nothing coming out, my lord.
Read the findings, sir.
Yes, my lord.
Read the point.
There's no finding at all, my lord. Nothing has been discussed. 129, my lord, just taken into account. No, nothing has been discussed, nothing has been said.
Okay.
So far that witness was concerned, PW 25, I have showed it, the
Yes.
last part, my lord.
Yes.
She is half truth witness, my lord.
Mm.
Likewise, my lord, this PW 30 is the material witness, my lord, that states something about me, my lord,
Mm.
because he was one of the worker regarding of a scheme. Evidence of PW 30, Pronis Probosa, LDA, typist, social welfare, Haflong reveals the special nutrition program is a scheme through which newborn child of the age 0 6 years were supplied feeding. The program is implemented through Social Welfare Department, Integrated Child Development Service, also falls under the Social Welfare Department from the Office of the Deputy Director. Anganwadi materials are also procured and supplied to the Integrated Child Development Service. Dietary articles and statutory articles are procured for maintenance of home for orphan and destitute children Haflong. His evidence also revealed that Exhibit 2 is a file containing the bill, challan, and after delivery of the materials, challans are certified by the circle supervisor and Anganwadi worker, and thereafter the bills and challans came to his table for passing for payment. When the bills for challans are found to be correct, he puts the seal for past payment, putting the amount, and after putting the seal of the deputy director, he placed the bill before the deputy director R.S. Khan, who puts his signature over the same. So it goes through a process, and thereafter it comes to me, and I, being the DDO, my lord, and the authority concerned, my lord, I have made my necessary signature. I put my necessary signature, my lord. His evidence further revealed that White, her letter dated 15/9/2009, Exhibit 82, Deputy Director L.N. Nampui had handed over the statement of fund for the year 2008-2009, Exhibit 82 to the Inspector Nia, and White Caesar Memo number 65. He had handed over 9 numbers of documents to Nia officer. Exhibit 83 is the file on the subject Anganwadi materials from headquarter bearing files such which were dealt in their office, and Exhibit 3 are the signature of R.S. Khan. The file contains quotation notice from the supplier, comparative statements of the rates and supply order. The materials are to be received by the concerned CDPO for distribution to Anganwadi Center. His evidence also revealed that Exhibit 71 is the cash book for the Office of the District Social Welfare, NC Hill, Haflong. The entries are relating to payment of different categories for material, etc. In the cash book, it contains signature of District Welfare Officer and Deputy Director Social Welfare. In Exhibit 73 at page 8 of the note sheet, approval of supply of blanket, mosquito net, and water filter was sought for, and the names of 7 numbers were person were submitted. Accordingly, the 7 person were approved by you on 29/9. I don't know how in the judgment, while writing the judgment, by you comes, madam. It's probably like
Probably it has been taken out from 313.
313. That is what I was
That is
saying.
the reason.
While preparing 313, madam.
Yes.
Accordingly, the said 7% were approved by you on 29/09 by the Exhibit 3. Pertaining to the received payments voucher in all scheme from January 23, there are money received challans and bills, and your signatures appears in the bill only. Exhibit 69/21 to such where the bills of Boral Enterprise, where the signature of R.S. Khan appears. These are all official works, my lord.
Yes.
While doing my official works, my lord, I have been doing it, my lord, as per the norms, my lord. Now, if we come directly, all these are the documents that has been discussed. I'll come straightway to the cross, my lord, how the court dealt with it. Cross-examination of these witnesses reveal that the bill Exhibit 62 were accompanied by delivery challan, which reveals that the materials are received by Anganwadi workers and supervisor concerned and signed on the delivery challan against their name of the concerned Anganwadi Center. Since he was the dealing assistant of the scheme of special nutrition program in the office of the Deputy Director Social Welfare, NC Hill, Haflong, so he has verified the bill and delivered the challan properly and found it to be correct in a due procedure, and thereafter he has written the contents of the same and by put his initial, and accordingly the bill was passed for payment. Cross-examination of this witness also revealed that Exhibits 62 and 62/149 are appearing at page 91 1. Exhibit 62 to 148 and Exhibit 69 is the bill submitted by Minaret Club in connection with the work order such dated such is a bill of this bill is accompanied by delivery challan at page 94 submitted by Minaret Club in connection with the work order number such. That is PW 99 Minaret Club.
Was
I will
this
show
man-
your lordship regarding to his deposition, my lord.
Council, was this man put to trial for Prevention of Corruption Act?
Yes, my lord.
What happened in that?
Thus the trial is on, my lord. So
Still going on?
special case 6.
6 of 12.
6 of 12, probably evidence stage.
13(1)(d).
13(1)(d) misconduct, my lord.
All right. Yes, carry on.
Then, my lord, if your lordship will now find the main finding at para 142(9), my lord. It is also elicited that the statement showing fund receipt and expenditure and fund balance 2008-9 issued earlier by IC Deputy Director on 15/9 in connection with letter number served by the examiner is incorrect statement. The document that has been produced was an incorrect statement that has been produced, my lord. Rashtrapati engineers.
Who says so that this is a incorrect statement?
PW 30 himself, my lord. In cross, my lord. Shall I read, my lord? Detail.
Carry on, carry on.
It's on record, my lord.
Yes.
To vis-a-vis exhibit C. Rather, it has come to light that exhibit C is the correct document because Nia during investigation collected exhibit 82 and C, which we have marked it. But 82 was not the correct one given by the bank, my lord. Rather, exhibit C, which was on record, we have exhibited it. That is the correct statement of accounts, my lord.
They have referred to 5 accounts.
I'm just reading it, my lord. That is exhibit. Exhibit 82, covering letter, my lord. In inviting reference to the subject cited above, I am to inform you that as per your query, I am enclosing here with a statement of funds for 2008 and 9 receipt and expenditure thereof, as reflected in the case book, as per statement to the office employee dealing with the cash book, who has also signed in the statement. However, in this regard, since all cash books except the NSCP are in your custody, the same may be verified if felt necessary. So this was never the original one, my lord, because it was a half-baked statement, my lord, that exhibit 82, my lord. Rather, when it came to the court and exhibit C was shown, my lord, which was in a type format, my lord, then it came to the knowledge that this amount was still lying, my lord.
We'll continue at 2.
My lord.
Item number 43 for judgment.
The appeal fails and is dismissed as being devoid of merit.
Deeply obliged.
एक second page पे correction है तो ठीक that you pointed out. That's the only correction I think.
For judgment, Case number retable 122 of 2019.
Second page correction. थोड़ा सा तो join कर दिया उन्होंने word में spacing नहीं था. The writ appeal is allowed accordingly, no order is to pass. The impure order passed by the single bench cannot be sustained, and as a consequence, the order passed by so and so is also reversed. The director of higher education shall consider the recommendation dated so and so of the governing body of the college for promotion of the plan from grade 4 to grade 3 in accordance with the rules of 2010 by passing a speaking order. Right. One more.
For judgment, case number retable 193 of 2021.
Inform the lawyers. Inform the lawyers, because this was listed today. Now. We have considered the rival submissions and have gone through the findings recorded by the DA and the learned single judge on the charge number 4. Suffice it to say that the banking transactions, public deposits in the account of the CA, which form the foundation of this charge, were admitted by him in reply to the charge as well as pursuant to receiving the inquiry officer's report. Thus, no evidence was necessary to prove the charge, which was a self-contained and a self-sustaining allegation. The burden to explain the sources through which huge cash amounts were deposited in the personal account of the CO in a duration of less than 11 months was clearly enjoined upon him by virtue of section 106 of the Indian Evidence Act. The CO failed to discharge the burden, and thus the charge number 4 was found proved against the respondent CO not by mere preponderance of probability, but beyond all manner of doubt. The finding recorded by the learned single judge that the CO was not given appropriate opportunity to defend himself is not sustainable on the face of the record, considering the aspect that no such plea was raised by the CO before the inquiry officer in the memo of appeal and the review petition. Hence, we are of the firm view that the learned single judge was not justified in interfering with and reversing the finding of the DA on the charge number 4. As a consequence, the conclusions drawn by the learned single judge are reversed, and the finding recorded by the DA to the extent of the charge number 4 are restored. Now coming to the question whether the award of penalty of removal of service from this on this solitary charge would be justified. We find that the charge number 4 was found proved as the respondent CO failed to lead evidence so as to justify cash deposits totaling to rupees 6,44,000 in his savings account. The respondent filed a written submission so as to justify these deposits, claiming that his wife and sisters are all government servants and the amount so deposited were contributed from their salaries. It appears that the respondent was misdirected in not leading oral evidence so as to controvert this charge and to explain the deposits oblique entries. The omission appears to be caused by error of judgment or may even be on account of overconfidence. Thus, we feel that awarding the extreme and harsh penalty of removal from service for this charge would not be justified. The respondent has during pendency of this proceeding superannuated and is nearly 69 years of age. Thus, we feel that ends of justice would be served by directing that the respondent shall be deemed to have been compulsorily retired from service from the date of the order of the disciplinary authority. The appeal is partly allowed in these terms. Yes.
My lord. My lord, before lunch, my lord, we are on exhibit 2 exhibits, my lord. Because on the same content, there were 2 exhibits, exhibit 82 and exhibit C, my lord. Oh, exhibit 82 shows there is a gap of 19 crore rupees, which might have been reflected. And exhibit C, the same thing, my lord, which we exhibited it, my lord, that shows that there was a surplus funds available in the accounts of the.
Have you asked that question to any witness?
Yes, my lord, that has been asked. my
To
lord.
whom?
Yeah, I'll show you. 30, my lord. He exhibited that document, my lord.
PW 30.
30, my lord. Page 155.
Have you given it in your compilation?
Yes, my lord. The running page is 103, my lord. Page 2. Exhibit C 2.
103.
Yes, my lord.
Read, please.
That your lordship will remember, my lord, that 150 page cross, my lord. Actually, all copy paste cross. My lord, page 262, running page 210 of my paper book, my lord. Aru kunba question hobe? Read kotha? How shall I read, my lord?
Just a moment. 210?
262 is the paper book page. My running page is 210.
Yes,
And
read.
the inner page is 108. Cross-examination of accused R.H. Khan. Exhibit C is the statement showing the total fund received scheme-wise expenditure incurred from NC Hill Autonomous Council. I am acquainted with the signature of T.T. Dolagappu, in charge Director, Social Welfare Department, Haflong, is the signature of T.T. Dolagappu, which I know. And there's another witness, if I remember it correctly, my lord, says that PW exhibit C is the correct and 82 is not correct.
Where?
That was. Parvasa, my lord, PW 45 million.
You didn't ask this question to this
Yes,
witness?
that part I'll read, my lord. Parvasa 300 of R&D. No, that very particular part. 229. I got. Yes, my lord. Page 229 paper book and running page 177, my lord.
Of your paper book now you presented.
Yes, my lord.
Page 177.
7, sir. Paper book page 1. Exactly asking into exhibit C is the right.
177.
Yes.
All right. 232.
Yes, my lord.
Yes.
229, my lord. 177 is the running page. According to the statement issued by Deputy Director Social Welfare Haflong on 28th, total fund received by the Deputy Director Social Welfare Haflong during the year 2008 and 9 is rupees 29 crores, such and such amount. And according to the statement issued by Deputy Director Social Welfare Haflong, 2111 total expenditure incurred by the Office of the Deputy Director Social Welfare Haflong during Iman is rupees 10 crore. And according to the statement issued by the Deputy Director Social Welfare Haflong, total balance remains in the Office of the Deputy Director Social Welfare Haflong during the year 2009 as on 31 is rupees 19 crores. The statement showing fund receipt and expenditure and fund balance 2008 and 9 issued by the in-charge Deputy Director on 5/10 in connection with letter number such and such by Iman, Exhibit 82 is the incorrect statement.
Did you put this question to the IO?
IO doubtful, my lord. I think we'll have to.
Who is the scribe of Exhibit 82?
Well, 82 is the office personnel who has given it, my lord. I've shown it.
Who has proved it? Who has proved it?
141, my lord.
PW 141.
140.
Even he prepared, but it was not exhibited through him. In charge representative.
141, my lord. I told you, I will- Deputy Director, Ensure Social Welfare, my lord.
PW 141 you are reading.
My lord, I'm
Nampui.
finding it out because it is not in my paper book. It was not taken into account, my lord. So it was not in the paper book.
You say, you asked this question that Exhibit 82 is the incorrect statement.
Yes,
But who is the scribe? This question
scribe
could have
is
been put to
different,
the
my lord.
scribe, not to this witness.
Yes, my lord.
Who's the scribe? Who issued and who proved it in evidence?
Yes, yeah, I get your logic. Exhibit 82 is not exhibited by him.
No, it was executed by 30.
This lady prepared it over.
Yeah.
Mala, I get it. Mala, Exhibit 82 was prepared by PW 141, but it was exhibited through PW 30.
30 people.
PW 30 is
30. But the maker of the document is 141. But unfortunately, as I could see from the evidence in chief, my lord, there is nothing regarding Exhibit 82, my lord.
in read PW 30, then
Yes.
what have you asked to PW 30
Yes, ma'am.
regarding Exhibit 82? This is what you have asked.
Yes,
This is a statement of PW 30 only.
30 only.
That is 30. Incorrect.
Right, right.
Incorrect statement.
Okay.
Who has
Any
exhibited-
re-examination by the prosecution?
My lord?
Did the prosecution re-examine the witness?
No, no,
In this
no,
one.
nothing else.
Okay.
But rather, it should come from the mouth of the maker of the document who was also examined as PW 141, my lord.
Let us see 141. What
Yes,
it
my lord.
says.
Now give 141, now give it. Iman কথা কলে বহুত 141 তুলে দিয়ে না এই মাত্র দিকে
Nampui
নাম হুই my lord.
320.
Yes, my lord. Page 666. In the year 2009, I was working as election officer. On 18/6, the Deputy Commissioner Haflong deputed me by a written order to be present and accompany NIA team during inspection. Accordingly, NIA team, myself and other officers visited the Office of Executive Engineer of the PHE department. Haflong along with other officers. The NIA office-
She was just participating with the Ayub
Yes.
during seizure of the documents.
No, that's why I am saying, my lord, that she was never put that question as a maker of the document. If you're
But how do you say that she is the maker of the document?
Yes, for the exhibit document, my lord. Covering letter, my lord. My lord, if your lordship will see exhibit 182, my lord.
Exhibit
Covering letter.
Exhibit.
Page already, last time I pointed out 518.
Volume 3.
Yes, my lord. No, भूल से आया तेरे कहते हैं ये पत्र से पता ही नहीं है क्या नो यार डायरेक्टर फॉरवर्डिंग से एक ही है ना ये तो बात है ना एक तो एक Your lordship got it, my lord, two documents. That is page 519 and 518, my lord. Is the forwarding letter. Your lordship will get it down below. Yours faithfully, LZ Nampui, Deputy Director, Insert Social Welfare, NC Hill, Uplong. Now, that is a forwarding letter of exhibit 82. And 82, my lord, will see down below, my lord, the maker, Deputy Director, Insert Social Welfare, NC Hill, Uplong. And this witness also says, my lord, at page 229, according to the statement issued by the Deputy Director Social Welfare Haflong on 21/11/2013, total fund received by the office was such.
Where does she say?
My lord, at page 229.
229. No. Nampui, you are talking.
Nampui, oh, that is what I'm saying, my lord.
229, her statement starts at
666, my lord.
666. Now where are you reading?
I'm reading vis-a-vis PW 30, my lord, because 30 exhibited this document. Right, my lord?
Right.
But the maker and forwarder of the document is PW 141. Nothing was brought out in the examination in chief.
Okay.
It was, she was the best person.
She prepared the statement?
Yes.
No, compared by a P. Barbosa, S. Sazem,
Yes, my
and
lord.
K. Francoy.
And it
So-
is under her, everything worked, my lord. And she is the final authority who has signed it. That is Deputy Director in charge Social Welfare.
Yes.
Barbosa is PW 30
Rankal 45.
and Rankal is PW 45. The comparison done.
Okay, this,
This H Sajan was not examined, my lord.
okay. Yes, Mr. Prosecutor. Mr. Prosecutor, how did you prove this document? Take note of it because the document has been prepared by L. Nampui. She has not proved it. You have not proved it in her evidence. It has been exhibited in the evidence of PW 30. He simply compared it. And in cross-examination, he says, this is an incorrect statement. There is no re-examination. Take note of this argument. Yes.
Yes.
Okay. Very well.
So coming to exhibit C now, my lord.
Yes.
We'll just like to show two things, my lord, from here. If your lordship will say it is in page 1144, my lord. Volume 2, 8, my lord. Volume 8 of the material exhibit.
Who prepared that document?
My lord.
Who is the scribe of that document?
The same Deputy Director Social Welfare, my lord. I see it down below, my lord. We'll read it in the evidence, my lord. Who is
Page.
Page 1144, my lord.
1144.
Yes, my lord. That is the exhibit C, my lord.
Volume 8. It's
Volume
not-
8, my lord,
No.
of the exhibit, my lord. Paper book.
Volume 8 start from 1615.
Oh, yes, my page. Exhibit 416 to exhibit 462.
Yes. So page, what is the page?
Page is 1144.
How can it be? It starts from
I don't know,
1615.
my lord, marking is that way. 1740. Sorry, it got cut, my lord. 1744. I'm so sorry, man. This one got cut in the top. I'll just stand corrected.
Yes, exhibit C.
Sorry, man. Exhibit 3 is this document. Your lordship will now kindly come to the right hand two columns, my lord. Amount available in SBI Haflong on assumption of charge by LZ Nampui, 144 PW. No? 144 on 4/8/2009. Remarks. Then I'll first take to this thing. This is 11 crore or something like that, my lord. No, this is number.
No, 2 crores 10 lakhs.
2 crores 10
2
lakhs.
crores 85 lakhs.
Yes. Exhibit 82 is.
2 lakh
mentioned.
55,000.
So all these were there. Then, my lord, we'll see down below. Total fund received during the year 2008 and 9 is 2 crore, 30 crores, I believe, my lord.
29.
Yes, my lord. Total fund received during the year 2008 and 9. total expenditure incurred during 2008 and 9, 1 crore or 10 crore. Balance as on 31/5/2009 is 19 crore. Expenditure incurred after 31/5/2009, 498 crore.
Deficit 1401.
1401.
So 14 crores.
Yes, my lord. Actually, it is put in the bank which was freezed by CBI. Bank
No, no.
balance in department account this year and the freezed account is 14 crore 63 lakh 34,789. Now, if we come to column number 6 on the right hand side, my lord, during CBI investigation, the following amounts are found on 23/7/2010 in SBI Haflong and presently under freeze by CBI. Account number such 14 crores 24 lakhs 14,5789 and these DRC 39 crores 20,000. That is-
39 lakhs 20,000.
Yes, minor 39 lakhs 20,000. So this part, the NIA has not deliberately investigation or gone into this effect into these two bank account. Because if it have gone into it, they would have found that this amount is already transferred and deposited in the bank accounts, my lord.
But even your exhibit C says that there is a deficit of 14 crores.
Yes. why the-
1400 lakhs.
Yeah, absolutely, my lord. Why? Because that is already deposited in that account number, my lord.
Okay.
6th column will reflect number 1, my lord. This aspect has not been brought.
All right.
Office account show deficit, but it's lying in the bank which has been frozen, my lord, by the CBI. So that's why it is said that 82 is incorrect, C is correct because of that mismatch.
Okay.
Hey, line to Napal, no? Okay. So now coming back to the other aspect, my lord. I'm now dealing with the evidence of PW 30, my lord. The person who has thrown light on this, my lord.
Yes.
My lord, that is now I'll just to go directly to the point as your lordship wants it that way. 1960, my paper book running page 123. Para 142.
1, 2, 3.
My running page.
You are talking of the judgment now?
Yes, yes, yes. Because that part I have dealt with now, how it was dealt by the learned trial judge, my lord.
Internal para number of judgment?
Para 142, my lord.
142,
Internal
yes.
is 10.6.
142 subpara?
Subpara 16, my lord. Page, paper book page 1960.
Yes.
He confirmed, that is PW 30 confirmed exhibit C is the statement showing the total fund received scheme wide expenditure incurred from NC Hill Autonomous Council. I am acquainted with this signature. It should be probably he is acquainted with the signature of T. Dologopu, in charge Deputy Director, Social Welfare Department, Exhibit C.
So T. Dologopu is a witness examined. No, Kulendra Dologopu is.
No, no, no.
T. Dologopu has not been examined.
No.
Okay.
No, Haflong Exhibit C is the signature of T.T. Dologopu, which I know. On 18/6/2014, the Office of the District Social Welfare Haflong was
2005 or 2014?
2005, my lord.
Yes.
18/6/2005, the Office of the District Social Welfare Office Haflong was upgraded as Office of the Deputy Director Social Welfare Haflong. The staffs who were working in the District Social Welfare Office of Haflong were retained as the staff of the Office of the Deputy Director Social Welfare Haflong. All the files, cash book, which were earlier used in the Office of the District Social Welfare Haflong were automatically used by the Office of the Deputy Director Social Welfare Haflong. The cash book, White Exhibit 71, was earlier used by the District Welfare Office NC Hill Haflong up to 19/5/2005. And after upgradation, the Office of the District Social Welfare Office into Deputy Director Social Welfare Haflong. This cash book was automatically used by the Office of the Deputy Director Social Welfare Haflong. It is true that Deputy Director Social Haflong has issued the supplied order White Exhibit 73/8 to 7 numbers of farm person as per approval of the council. So this is the This file, not filed, it is filed. This file by exhibit 73 is not the original form and it may be broken after seizure language, my lord. Exhibit 73(6) is the note sheet dated such, and as per this note sheet, the name of the supplier list is enclosed for approved stage, approved at page number 36, but at page 36, there is only a work order. So probably the file got loosened up during investigation as the court field. Now we'll come to page 1961, para 142. Regarding supply and non-supply of the material good. Shall I come, my lord? Para 142.
142, yes. We are
Yes,
reading.
that is the negative finding, my lord, which I like.
Para 142 subparas we are. reading.
Subpara 20, my lord.
Yeah.
The
we are
double
reading
X,
that one,
my lord.
Yes, yes.
Well, before that, just before that, 3 lines stop, my lord. That's a one line, one para coming in my favor for finding way. So the work is properly executed and the office of the deputy director passed the bills for payment. So the office of the deputy director has done no irregularity in performing the duties and followed the norms and procedure before the bills were passed.
This is simply reproduction of the
Evidence, my lord.
evidence.
Evidence.
Yes.
Because no observation, no finding as such is this given, my lord.
That is at subpara 20,
Yes, my lord.
Roman 20.
Yes, my lord. 20, my lord, I'll just read, then I'll come there. Because the court comes into the conclusion that I was deposing, this witness was deposing because he was my one-time subordinate. I was his boss. That is the language used, my lord. So that's why that cannot be pursuing, my lord. That is their witness come, we have cross-examined, demolished them. Sorry, my lord. Is to be mentioned here that a query, probably spelling QUER, right?
Right.
Yes, put by the court to the effect, did he receive articles supplied to his office dealing assistant, to which he replied as no. Now I clarified that, my lord. Why this come as no, my lord? Because it was not his duty to receive the material. It was the
Not the
duty
store clerk.
storekeeper. Absolutely, my lord. I'm obliged, my lord. We read and read, then got it, and your lordship got it one moment, my lord. It's already there, my lord.
Was there any other store in charge in the office?
Yes, my lord. He
Help that.
he was PW.
No, he was not.
He was not examined, but he was a charge seated witness. So
the
I
name
will
there
say
anywhere?
this way, my lord. The prosecution became wiser if we examine him. He will say in his favor, so he was not brought into examine in the witness box, my lord. So now this finding, the learned counsel for the accused during argument submitted that this witness has cleared in his deposition with document that no fund of social welfare was siphoned off and the accused had no connection with DSD, an anti-social organization. But in view of the admission of the witness that he has not received the article supplied to his officer,
Yes.
was totally negate what he faithfully obliged to his one-time boss in cross-examination. The big question mark about this.
Yes.
The big question mark is about his reliability. My lord, this is not a correct finding. I will use the word purpose or some summarization and conjecture, my lord.
Yes.
There, because the evidence should be written before in the court, my lord, then only it can be read. Either they could have easily declared him hostile and cross-examined.
He should have been re-examined, cross-examined.
Yes,
Whatever.
Yeah, whatever. One thing ought to have been done, my lord, but nothing was done, my lord. The storekeeper was charge seated as witness PW 69. Well, I prepared the note. I'll give it to your lordship, my lord, after my conclusion, or their reply. So I have concluded PW 30, my lord, who was the star witness of regarding defection of money, siphoning of money. Nothing has come out. Rather, the court on certain vague assumption, my lord, that he has obliged me, he being my subordinate, which is not the correct finding, rather is a purpose finding, my lord. Now coming to PW 34. This witness is no way connected to me, my lord, because of the fact that he dealt with the PHE, my lord. But just to happen my submission, my lord, if your lordship will see that this last line, my lord, next page, 125 page. In a paper book page 1962. How the matter was dealt, and my reply will be this, my lord. This witness is not cross-examined by accused R.S. Khan. Well, why should I cross-examine him when he is no way connected with it? And he has said nothing against me. So, my lord, as your lordship know, my lord, sometimes there are rebuttals also, like in the check bounce case, my lord. Presumption is there. I don't have to disprove that. I can cross-examine him and demolish him. The presumption clause will go, my lord. So here to beyond all reasonable doubt is the fundamental criminal jurisprudence. So whether I cross-examine on material, what is there, my lord? That is the duty of the court to look into, to put it in a shiver and filter it down, my lord. But nothing as such is done. Then again coming to PW 144, PW 35 Muhammad Imdad Ali. He also relates to PHE. Same line, my lord, mentioned to be made here that accused R.S. Khan has not cross-examined. That since this PW has not attributed anything against the info, so there is no need, my lord, for the cross to be done. And this Imdad Ali, as I feel after reading the evidence, my lord, the IO, why to my utter surprise has left it, I don't know. He was the person who was found carrying money, my lord.
He was supposed to be accused.
He ought to be one of the accused, my lord. I'll not cast any aspersion on anybody, but as it surfaces, my lord. Because he was found carrying 61,45,000. Another check was also given by Ghosh. He also confirmed him for commercial bank. That was found from him, but he was left out and he was made a witness. Some explanation was given, he is mad or something like that. But this is medical ground, psychiatric treatment, something like that. Then coming to PW 37, he is an important witness for me, my lord, dealing with my aspect. The evidence of PW 37 Pradeep Kumar Ghosh UDA accounts reveals that he was posted at Haflong in the year 1989 to May 2008. During that time, your lordship, the dates are important. He was there in the office till May 2008. And the case and these things all happened in the part when the conspiracy started on November 2008. So 6 months before he was transferred, my lord. Rather, he took voluntary transfer. During that time, R.S. Khan was the deputy director, social welfare. His evidence further revealed that his job as accountant was to prepare bill, receive material which were supplied by the supplier, and the said material were distributed to supervisor and office staff as advised by R.S. Khan. He received the material as supplied by the supplier in good condition, but sometimes there were short supplies, and informed his superior, R.S. Khan, who advised him to receive the material, telling him that supply will be made later on. His evidence also revealed that he took transfer from Haflong to Borobazar Bizni ICDP sometime in the June 2008, as R.S. Khan used to become angry on him. Cross-examination of this witness could elicit nothing tangible to discredit his version in chief. However, it is elicited in the cross-examination that during his period from 2003 to 2008 at Mahur ICDS project, he prepared supply bills after receipt of materials fully from supplier against the supply order. He also admitted that he has not seen any documents before the court today regarding He has now admitted he has not seen any documents before the court regarding receipt of materials by him from suppliers. The learned counsel for the accused has submitted that in view of the admission of the witnesses that he prepares supply bill after receipt of materials fully from supplier against the supply order, and as such there is nothing incriminating against the accused. But a plain reading of the two statements that sometimes there were short supply on material, and he informed his senior R.S. Khan, who advised him to receive the materials, telling him the supply will be made later on. And then he prepares the supply after receipt of the materials fully from the suppliers against the supply order, meaning the true import thereof is found to be totally different. Preparing bills after receiving articles fully that there were short supply have two different meanings. having viewed both the statement from the standpoint of their meaning, we are inclined to hold that the later statement has never obliterated the force of the former one. So my respectful submission, if a lordship will now go into the evidence on record, we'll find a different note, my lord. Page given as it. PW given as it. 37, Pradeep Kumar Ghosh. So
Yes.
my cross, my lord, which I have done, my lord. I'll read the negative line, my lord, appearing against me. Page 292, which he already dealt with it. First line, R.S. Khan, who advised me to receive the materials, telling me the supply will be made later on. I was transferred to Borobazar Bizni project sometime in June 2001. I got transferred as R.S. Khan used to become angry on me, for which I took my transfer for Haflong. But if your lordship will see that this is not in consonance with his 161, this is an afterthought built up statement, improvised statement. Your lordship will now come to the cross part. These are the two only aspects that is coming against R.S. Khan. I received them in his chief till the last, it is in favor of the accused. I received the material as supplied by the supplier in good condition. Sometimes there was short of supply, and I informed my superior R.S. Khan, who advised me to receive the materials. Right, my lord? Now coming to the cross. During the period 2003 and 8 at Mahur, I prepared supply bill after receipt of materials fully from supplier against the supply order. The distance between Mahur project and office of the deputy director Haflong is 31 to 32 kilometers. Though I was posted at Mahur ICDP project for period 2003 to 8, but I was staying at Haflong town and was attending my Mahur office from Haflong. I have stated before the IONIA, as my wife submitted an application to Director Social Welfare Guwahati for getting me posted either in Guwahati or in Dhubri due to domestic problem, my lord. So his 161 admission contradicts this part. I was transferred to Borobazar Bizni ICDP in June 2008. It was not transfer, rather he has voluntarily on medical ground sought the transfer. It is not because of me. It is not because that he was not cooperating with me for short supply or something like that. So he is not a trustworthy witness at all. So his account cannot be relied upon, my lord.
All right.
But further, there are two lines. I have not seen any documents before this court regarding receipt of materials by me from the supplier, because through him, nothing was exhibited, my lord.
Like that we've seen. Yes.
Nothing was exhibited. So no document was shown to him as to what was the supply they are talking of, as to what was the material that was in short supply. Then this suggestion comes, my lord. I will not take it to your lordship to that, my lord. So these are the two things that are emerging from that part, my lord. So the court felt that when there were two views, my lord, the one that was favorable to the prosecution was taken. With all respect, it should be the other way around, my lord. So that is what this learned trial judge has said, will not obliterate the force of the former one. The former ones means probably, according to my understanding, is the examination in chief. But in the cross-examination that has come in the 161 admission form, my lord, admission form, that is not taken into account, my lord. Then this PW 41, he is one of the postmen, my lord, postmaster at Haflong. And he inquired about the existence of the farms to whom the works were given, my lord. Whether they are in existence, whether they are fictitious farms, or whether they are dubious farms, my lord. For that, the NIA examined this witness. Because the postmaster went to deliver the letter posted by them, NIA, and then the report was prepared of 30 registered letters which were sent, my lord, to different farms located in the NC Neflo. But the postman in the area could not trace the address and returned it as non-traceable. So in the cross-examination, it has been elicited, my lord, that actually, my lord, it was incomplete addresses. So it could not be delivered. And the report of 30 letters were prepared within 6 hours, if I'm not wrong. Within 6 hours, and it was given to NIA with that report.
Regarding the existence of the power. Why is it?
Page go, PW 41.
Yes.
I'll take your lordship to the evidence.
Did
my
the
lord.
IO himself not make an investigation?
No,
This is the mode of investigation for existence of firm.
yes, my lord.
That's all.
Yes, my lord.
Yes, Mr. Prosecutor. This is wonderful investigation we find.
Theory of matter.
You send a postmaster to make your investigation.
Oh,
Designation, delegation of powers.
Sir,
What
he's
was this?
addressing you.
We are asking you,
Theory of matter.
what kind of delegation of power is this?
Chief of Office.
We asked some clerk in the registry to write the judgment, right? What is this nonsense? This is a premier investigating agency of the country. Behaving in this manner. You send a letter to the postman and the verification is done.
It will not be that way.
Why could you yourself, the IO himself go for a physical verification?
This one goes to monitor.
The addresses were there. They were fictitious that had to be verified by the IO himself. How? We'll find out now. You collect evidence now. Okay, carry on.
Yes, my lord. And he was the postmaster. It is the postman who visited those offices. They were the best person to say, actually, my lord, how, why and how the letters were not delivered and for what reason it was not delivered. So if your lordship will now see the evidence of this PW, my lord, PW 41, my lord, it starts in my running page 237 cross, paper book page 317, my lord. And the relevant part is at 319. It's not 6 hours, but in 24 hours, the whole 30 letters report was given. Opening line.
Yes.
That on 13/8/2009, your lordship got it, man. That on 13/8/2009, I was called by the office of NIA, and accordingly, in the evening time, I went to NIA camp at Circuit House, Haflong. Then this letter white exhibit 120 was handed over to me by the NIA officer. On the next day, I have submitted the report. In exhibit 120, the address of the addressee farms are incomplete address. So if the address is incomplete, my lord, it will never be delivered, my lord. It will always be returned to the addressee. When our office receives a letter from any other office or any person, then the letter must be recorded in our receipt register. I do not remember whether 120 was recorded. So these are all technical aspects, my lord. But what I'm trying to show that within one day, the postmaster, not the postman, my lord, who went there for the reasons they have to write in the letter, as your lordship ever in the NI cases, my lord, refuse, person not found, address incomplete, my lord. And now the main part is that the postman goes, but the report is given by the postmaster. That is another aspect. So if your lordship will now see page 321, the postman, which I am saying, my lord. On the top line itself, I'll take your lordship. There is an endorsement of postman as insufficient address, so returned to the sender. According to me, also the address of the addressee is not incomplete. I am not acquainted with the signature of the postman appearing on such exhibit. In exhibit 128, there is an endorsement of the postman as insufficient address, so returned to the sender. According to me, that is the witnesses of own opinion, own swearing on statement. According to me, also the address of the addressee also incomplete. And I am not acquainted with the signature of the postman. Those exhibit numbers has been given. I am not connected with the delivery of the letter from exhibit 122 to 122/30, and I have got no any personal knowledge about the delivery of these exhibited letters. So interestingly here, one re-examination comes from the prosecution side. Under objection by the defense on the ground, the re-examination has been done after cross-examination. Even if the postal index number is not mentioned in letter received by post office in a normal course receiving letter, but still the delivery of such letter is possible. Even if post office is not mentioned in a particular letter, more particularly is a registered letter, the same can be delivered by postman if the address is proper. So here we have an improper address. Exhibit 122 by 1 to 122 by 30 in some exhibit, though pin code was not mentioned as well as the post office, but registered letter could have been delivered, though there is no mention of pin code and post office. So it is the postman who went to deliver the letter were the best person to throw light on him. So this is where the firmware in existence or not has been examined, madam. And now on this, the learned trial code below, my lord, findings is at page 126 running page, para 147. Roman 1, lord. That point, short time was given. The learned counsel for the accused has submitted admittedly.
Second page, submission is found to be.
Yes, my lord. Yes. That is the only finding given to the survey, and it is not possible to go service total, and the postman was not examined by the proceedings. The submission is found to be benefit of merit, as nowhere in his evidence PW stated that due to short time they could not locate the address. It is similarly impossible, my lord. Then PW 42, my lord. Tomizuddin Ahmed, he was the senior scientific officer of the FSL, my lord. Yes, my lord, I have got nothing to do because all these documents pertains to PHE department, my lord. Okay. That Corona Soikia's department, my lord, who is not before your lordship now, since his appeal has been abated, my lord. Then we'll go to again.
Then why did you advance arguments for this accused referring to this witness?
My lord, I don't know why the learned trial judge has taken it into account.
Okay.
That's why at the outset I said 32 witnesses, out of which 15 are no way connected or related to me.
All right.
And out of that 15 are related and 2 are also not related because nothing was discussed regarding him.
Oh, okay.
Then again I skip PW 43. Next page 128, my lord. Para 149, Minendra Narayan Bora, Deputy Director of Question Document, FSL, my lord. This also relates to this relates to us, my lord. Minendra Bora, Deputy Director is the Question Document Division for testified that on 8/10 in examine certain documents from the Superintendent of Police NIA, New Delhi White Memo number such, and expressed his opinion thereof. On verification of the documents, he found one money receipt for rupees 14,62,000, originally marked as 71, and one bill quotation for the same amount of money. The standard writing and signature of Sopan Kumar D in 14 page, the standard writing and signature of Thangla Dalagupa in 4 sheet, and after the thorough and exhaustive examination of the question signature and comparison with the standard signature, he expressed my opinion. It should be his opinion. He expressed my opinion, his opinion, exhibit 170, and he assigned reasons for opinion, exhibit 172 as under 43. Minendra Narayan Bora recorded his opinion and reason thereof as under number such, the disputed signature. So these are all relating to 2 other persons. Now the finding of the learned trial court is 149, Roman 1, my lord. The learned counsel has submitted that this witness has given his report without any basis, who admitted in cross-examination that with the passage of time, there may be natural variation between the signature put by him in the year 2009 and 2014, and in exhibit 170 has no basis.
What are these documents, by the way?
My lord, these documents were that whether he has received the money by signing it or not.
This accused RH Khan. RH Khan.
No.
Then
The one contractor, my lord. Sopan Kumar Dey.
Contractor.
He was the registered contractor. And the person whose signatures were obtained, were the best person to come and take the witness box and say that yes, this document is a forged document, I have not signed it.
He was not examined.
Not examined.
Cited witness, but no.
Though they were cited witness, but not examined. That is the interesting part, my lord. I don't understand why cited witness were withheld, my lord.
Okay.
So brought the handwriting expert to break door. only to show, but also in the cross, we have tried to demolish it, my lord. And we find that this witness has given cogent reason for the decision here after merely because he admission that some natural variation may occur in putting signature after lapse of time cannot be ground for gestation, the report of an expert. Because while giving these signatures, my lord, it traveled some 7 years or something like that when his specimen was taken. So when the original was there were some variation, my lord. But the base person to come and depose before the court was the person whose authorship is in question. He is the base person to say whether it is his signature, whether he has received that money or not.
Yes.
That exercise was never carried out by. Then para 150, my lord, he is one of the witness dealing with my department, my lord, accused department. The evidence of PW5, K. Harankol, UDA, Social Welfare Department revealed that with regard to procedure for purchase of material in Social Welfare Department, the office calls for tender quotation for supplier. If the tender is not called for, they follow the approved rate given by the Autonomous Council. His evidence revealed that in the year 2008 and 9, the following schemes were taken by Social Welfare Department. Such were the schemes, my lord. So if we go one by one, it will take a lot of a time, my lord. We'll go directly to the finding, my lord. My 150 para 6, my lord, cross examination part. Page 132, my lord, para 150, Roman 6. Cross examination of this witness revealed that in his 161 statement before NIA, he had not taken the name of Dhruvo even once. It is also elicited that he has worked in the Social Welfare Department Haflong for 26 years. It is also elicited that R.S. Khan worked in the Social Welfare Department of NC in Haflong from 1806 as District Social Welfare Officer, which post was renamed as Deputy Director Social Welfare Department till the date of his arrest. He was therefore worked under R.S. Khan for more than 11 years. He admitted that in section 161 statement given by me, that is given by him to NIA. Me means direct transmission. To NIA, he stated that today I have shown one file. That is the drawing of the attention of the statement of 161, my lord. Given to me by NIA, it is stated in respect of to fill all the positive statement has been drawn, my lord, in the cross examination. Now let us come to the finding if it is in. Well, probably it is in 150 para 10, 5, 6, 16, my lord. Before that, my lord, 150 para 16, my lord, Roman 16, page 137 of my paper book. The file by exhibit 212 is not the original condition desired by CM, Chief Executive Manager, implies as approved by District Council White Exhibit 212. CM is the head of the council. White Exhibit 213, the file is not in the original form. The main line. The scheme undertaken by the file White Exhibit 212 and Exhibit 213 were properly executed. So all works were done. In re-examination by the prosecution, he stated that during the relevant period, he was only working in the office of the UDA and he was never working as a storekeeper. So it is the prosecution witness. They brings the witness. And when in cross it is demolished, then they come up with the re-examination by some way trying to remake the damage done, my lord. After re-examination, main thing against that, in cross examination, after re-examination by the prosecution, this witness admitted that Exhibit 212 by 2, there is no endorsement and signature of Ma Trading, Boral Trading and Debashis Bhattacharjee. He also admitted that in Exhibit 1, there is no endorsement or signature of Debashis Bhattacharjee. There is no endorsement in the sale supply order that Exhibit 212 by 13 was received by Debashis Bhattacharjee. He further admitted that in Exhibit 212 by 15, there is no signature or endorsement of any officer of the Borough Enterprise to show receipt of the same. Similarly, in Exhibit 211-16, there is no signature or endorsement by any of the officer of Ma Trading to show receipt of the same. He also admitted In exhibit 13, there is no signature. Such thing goes on, my lord. Then ultimately,
17.
yes, my lord. Then ultimately we see that since the signatory of the same did not sign the same in his presence, only the evidence has been quoted, my lord. We would not figure it out, my lord, how the conclusion was drawn, my lord. What it transpired from the evidence of these witnesses, though he admitted that the handwriting appeared in exhibits such are of him, yet he never deposed that the signature appeared on the said exhibits are from him. My lord, the prosecution witness, it is not DW, my lord. PW, my lord. Had it been DW, my lord, things would have been in that way, my lord. But it is the prosecution witness, my lord. So lastly, my lord, one conclusion has been drawn, my lord, at page 139, my lord. The 3 lines conclusion, the honorable trial judge has written, the logical conclusion that can be arrived at from the above discussion is that there was a nexus between R.S. Khan and accused J.K. Ghosh Devashish Bhattacharjee for siphoning out the fund from the social welfare development without supply of material during 2008 and 9. My lord, if any prosecution can show this fact, my lord, from the record, my lord, I'll take my seat, my lord. But it's nothing is there on the record, my lord. From where this finding surface and how it surfaced, my lord, this thing to be taken note of, my lord.
Yes.
Siphoning of money, circular speed, whatever the business they were done, my lord, the supplier, my lord, they have got their dues, my lord, by executing the proper document like other contractors also. Then coming to para 151 PW 17, Kaushik Bajbarua, he was the executive officer of News Live, my lord. How I'm related, I don't understand, my lord, why it is taken into consideration, my lord. It was just the news flashing was done that 1 crore rupees was recovered, my lord. So R.S. Khan has got nothing to do. Then PW 85, Ajit Kumar Dhot testified that on 10/11 a requisition he handed over certain documents to NIA of the receipt of such and such. This also does not relate to social welfare department. Right? Then the main technical side of the evidence, which the prosecution has relied upon, is through PW 19 Romani, my lord. This needs some examination, my lord. PW 90 B Romani is the executive director of CDEC, that is Center for Development of Advanced Computing. His evidence has already been discussed in detail in the previous paragraph of this judgment. I did not find it, my lord, previous paragraph. However, his evidence is more significant so far as the accused R.S. Khan is concerned. Therefore, it is decided to discuss the same here also. His evidence revealed that on 11/7/2009, White Exhibit 304, a letter was addressed to the director, CDEC Trivandrum by Loknath Behra, NIA for examination of material object like hard disk. It was, I'll put it correct, my lord, 7 hard disks were there, though it is not written, but the evidence as it comes subsequently, it is 7 hard disks. CPUs in total 14 objects, etc. The later mentioned the nature of examination. One was to find out any deleted file that could be retrieved and also any file which pertains to sanction of work, supply order to contractor, copies of email, deleted files in the email, travel documents, if any, by both personal as well as official information of DSD photograph, picture, contact number, available communication with Mohit Hojai, R.S. Khan, Niranjan Hojai, Daniel Dimasha, David Dimasha, Murung Jubo Ghosh, Jayanta Kumar Ghosh, Partha Varisha, Joel Garlosa, etc., and other relevant material. So the NIA was under the impression that all the necessary nexus, they will find it in this CPU in the official. Even if deleted, it can be retrieved.
Yes,
So for that, it was taken into Trivandrum, my lord, rightly done so to find out the truth. But what ultimately emerged is the most important thing that your lordship will find in exhibit 305 and 306. 5 and 6. His evidence also revealed that they requested for a supply of 4 high-capacity hard disk of 500 GB capacity. And on receipt of the hard disk, they carried out the forensic imaging and ensured the authenticity of the evidence by generating hash values of the 7 hard disk, and then did the analysis. In this analysis, they have looked at retrieval of the deleted file, information in unallocated areas, hard disk, the word searching examination, text document, PDF file, and after the analysis, they have found some deleted information, documents, PDF file, picture, etc. And they have retrieved this information and submitted the written report along with DVD to the NIA. Exhibit 305 is the forwarding letter dated 14/10/2009. Exhibit 306 is the report analysis in 25 pages with seal of CDEC under his signature, Exhibit 306/1. His evidence also revealed that in their report, they have concluded that they have recovered. This conclusion word is not correct, my lord. They have recovered a few bill, challan, and work order. They have also recovered some pictures. They have extracted evidence from the unallocated areas of hard disk in the said report. They have included DVD, which is organized exhibit wise, that is 1 to 7. These exhibits contain image files, Word file, PDF file. His evidence further reveals that after examining the material object, they have prepared a report and returned the material object along with the report. He has seen material objects number 77, a Dell laptop bearing serial number such. This laptop also contains the hard disk with serial number such, which was marked as exhibit 01 by the NIA when the article was sent to us. That is to him, it should be, which was sent to him and is shown to have been seized from Kulendru Dalakapu. This was examined and submitted our report. I mean, it should be their report, White Exhibit 306 at page 5 and 6. Then the material object, these two relates to the accused person, my lord. The material object number 78 is the hard disk bearing serial number such, which was marked as Exhibit 2 by NIA when the article was sent to them and is shown to have been seized from Phonica Swear and is shown to him in the court today, which is in seal condition as seal of them. This they have examined and submitted their report, White Exhibit 306. Material object 79 is another hard disk bearing serial number such, which were marked as Exhibit 3 by NIA when the article was sent to them and is shown to have been seized from Phonica Swear. They also have examined and submitted their report, White Exhibit 306, page 11 and 12. My lord, here if I pause it for just a moment, just to throw some lights, my lord, that these two material exhibits 78, 79 relates to my thing. Now they say that it was seized from one Phonica Swear, PW 25, which I have already thrown light in the morning session, my lord, that she deposed on oath before the court that it was never seized from her and she never gave it to her and she was never present. On the contrary, my lord, the data operator, who was the custodian of the said computer, my lord, was never brought into the witness box to translate it into evidence. So that way, my lord, it becomes doubtful the facts here. But suppose I read that part also. Now merit, what happens, my lord, that I will try to show.
Yes.
Because ultimately the merit, the factual aspect in a criminal case counts, my lord.
Yes.
Then going around or beating in the bushes, my lord. The material object 80 is the laptop. This doesn't belongs to me, so I'm skipping. My lord. Yes, my lord. Now we come to the RHK part, 153 para 567 down below, my lord. The material object 83 is the CPU Lenovo bearing model number 11Q with serial number such. The hard disk bearing model number such of the CPU was taken out while examining the same, was sent to NIA in seal condition. Yes, my lord.
7.
But because they wanted to connect us, my lord,
All right.
that whether we have connection with the terrorist organization or not.
Okay, okay.
Nothing was found, my lord. And we are coming into the ambit of this investigation by virtue of material objects 78 and 79 only, which is the hard disk extracted from our official computer, my lord.
Yes.
Now, another aspect which, according to us, my lord, is not in consonance with the procedure played by the trial court below, my lord, is regarding the playing of the material object as the DVD. According to us, it was not in a playable condition, my lord. But the learned trial court, for some reason, has written that it was played, my lord, but with all respect, I have checked it from my assisting counsel, my lord. There is no thing on the order sheet, my lord, to show that who brought the, yes, played before the. And where from the machines were brought for playing it, my lord.
DVD could have been played on a laptop. Not a big-
Maybe, my lord, but at least things should come, my lord,
Yes.
because everything should be in a.
Where is it mentioned? That it was played?
The plate is there, my lord. I'll give it. The plate to the. However, having gone through the report and played the material object, 85, the DV containing data which was sent to CDEC along with the report found to have contained one note such and such.
Where
My-
are you reading?
My lord, I'm reading my paper book page 142, para 153, 10. Okay, finish with it.
Yes. Played the metal. Mohit Dujai. Yes.
Joystree Kera, no?
Yes, carry on.
My lord, just vis-a-vis the evidence that comes into the picture, my lord, I'm reading it, my lord. This one PW 132, Joystree Khera. She has spoken it this way, my lord. The material exhibit 74 with the CD earlier proof in this case is allowed to be played in the laptop of the court at the prayer of the learned PP Nia. However, under objection of the defense side, after listing the audio clip, the witness translated the same as followed. This and this. However, she admitted in cross-examination that English translation which she had handed over to Niavara has not shown to her in the court. She also stated that as per her understanding goes, the conversation in the audio clip was in between two persons, and she also admitted that she is not a translator by profession, my lord. So this relates to the other object. So for our part is concerned, my lord, such type of petition was not filed. If I'm not card. Which is a to card was to play. This playing was done by the witness Khera in the laptop of the court for the voice of the Mohit. The same exercise, so for our RSK is concerned, that was never done. That is my submission, my lord. So that was never played. So for our articles are concerned, my lord. Then my lord, page 143, para 153 by 11. So it will make more things clear, my lord.
Yes.
In cross-examination, he admitted that exhibit 305 is a preliminary report, but not the final report.
Yes.
So it is an inconclusive report. In order to make it a legally acceptable report, it should be a conclusive report. He also admitted that in the report white exhibit 306, it is not mentioned that CDEC requested NIA for supply of 4 high-capacity hard disks, and he do not recollect the date on which they have received the 4 high-capacity hard disks for NIA. He also admitted that he determined the hash value of each of the hard disks before examination is not mentioned in my report. It should be in his report. He also admitted that in their observation made in his report in page 12, he has mentioned the material marked by NIA as exhibit 3 does not contain any image, PDF and other files related to DAD. Exhibit which were sent by NIA for examination by us were examined by Satish Kumar, and he had set it with Satish Kumar and verified the report. Satish Kumar is alive, but he is not with CDEC. I have not personally prepared the DVDs for retrieving the deleted files from the hard disk. Some software are generally used like Stellar, Phonex, recovered my files, etc. He also admitted having not provided any guideline along with the report as to how the hard drive image can be done. My respectful submission, my lord, the person who has actually given the report is one Mr. Satish Kumar. He is not examined in this case. The person who has modified his version in the court that I was sitting when this report was being prepared, he has been brought into the witness box. But the person who makes the report, who is alive, who is working somewhere, he could have been easily found dead too by NIA, my lord. He was never summoned, my lord, to come and take the witness box. Right. The learned counsel for the accused submitted that this witness did not produce any retrieved data along with his report exhibit 3. Mere report without retrieving data has no value at all. It is further submitted there is discrepancy in the discrepancy in the date, of receiving the materials for examination and the reference number. The date has been mentioned as 14/7/2007 in the report, which is improbable. It is further submitted the material exhibit number 84 and 85 were in open condition, and the certification as required under 65B Evidence Act is not appended thereof, making thereby it inadmissible in evidence in view of judgment of Honorable Supreme Court in Anwar PV versus Bashir. Besides, there is a discrepancy as material exhibit for 84 and 85 being DVD or CD. So that was also not determined, my lord, whether it was DVD or the CD, the transferred documents, my lord. Whereas the learned special PP has fairly admitted that the material exhibit 84 and 85 were in open condition, while PW 90 was deposing. The learned special PP has assigned reasons for the same. It is submitted that before the evidence of PW 90 is recorded, the defense side has prayed for supplying a copy of the material exhibit 84 and 85, and because of this, the same was open and copy were furnished. It is further submitted that though it was in open condition, yet PW 90 has confirmed that the same has not been tampered with it as because the generated hash value was not changed. We find the submission worth accepting and accepted it accordingly. The learned PP further submit that the present one is not the case where the certificate under 65B is necessary, as because here the hard disk from where the data was retrieved and transferred to material exhibit 84 and 85 were itself produced before the court and exhibited as material exhibit 78 and 79. As such, according to the learned special PP, the contention of the learned defense counsel is a misplaced one and was not the true spirit of the ratio. My lord, here I will pause and submit, my lord, that once the data is transferred from the main instrument and that instrument is sought to be exhibited in the case, then it becomes necessary because the transfer take place.
The person transferring himself came and deposed.
Yes, ma'am.
Then what is the need of 65?
Because it was transferred data, because that's why the certificate is necessary. My lord, in bank cases which we do in the NI Act, my lord, computer generated statement is taken out, but the certificate is given. The person who generates, he comes, my lord. He can very well say, I have generated, but no, under the banker's evidence also, evidence is there, my lord. But here, the law as it stands, and I understand, my lord, if suppose it's a original smartphone is produced and the video is played, then there is no certificate is there because there is no transferation, no any other format was used. The original itself is there. But once you take it out to another transferred, my lord, then 65B will come into play. That is my understanding. Subsequently, also in the case of Maharashtra, I've got the
Arjun,
yeah, right, my lord. Absolutely fine, my lord.
Yes.
That has made further more clear, my lord.
Yes.
Earlier, Anwar was the first point of time, my lord. Arjun case that was elaborately dealt with it.
Yes.
So this is Anwar's thing has been taken into consideration, my lord. Then coming to this page 145. The evidence of PW 99, Muhammad Zagir Khan, reveals that in the year 2009, the Honorable Trial Court was dealing with 3 hostile witnesses now, but very unfortunately, the other hostile witnesses were left over, my lord. But these 3 witnesses, hostiles, only their 161 was quoted and taken into account. I'll show it, my lord. The evidence of PW 99, Zagir Khan, he is the secretary of one minaret club of the Haflong, wherein sports goods were given. And the allegation, as the finding was there, my lord, I have read it in the daytime, my lord, morning time, that 15,000 to 25,000 rupees were paid to him in cash to get the signature of him, my lord. Now, what he has deposed, my lord, your lordship will see it for self, my lord. The evidence of Zagir Khan reveals that in the year 2009, he was working as assistant teacher at Molhoy High School, Haflong. In the year 2009, he was the secretary of the Minaret Club, Haflong. The state club is an NGO working for the development of sports and participate in any other sports organization, but also did social work. The NGO consists of 70 to 80 members. the NGO used to run on the basis of membership fee received from the members and donation received from well-wisher. In this connection, he met Principal Secretary of the Council, Sri Onul Kumar Borwa, with an application for financial help. Then he told him that there is no such scheme or financial aid. However, project scheme can be allotted to them for execution, as he directed him to approach Deputy Director Social Welfare, R.H. Khan, who was holding the charge at that time. When he approached Mr. Khan with an application and approval, the club had received money and he has received the same on behalf of the club. Exhibit 331 is a money receipt of rupees 8 lakhs 09, which he has received from Social Welfare Department for Minaret Club, is the bill submitted by the club, such and such. All these things are there, madam. It is to be mentioned here that I'll take the lordship to the cross. That thereafter the prosecution side declared this witness hostile and drawn his attention to his previous statement made before the IO, to which he denied, and then brought on record the statement given by him before the IO and proved the same through IOPW 148 Santosh Kumar Singh, who proved that this witness stated before him that on two occasions he gave me cash for amount of rupees 15,000 and 2,000 respectively. So this part was taken into consideration and finding while writing the judgment, which will be a purpose and not a legal finding, because this is the 161 statement whose attention was drawn, and the witness PW 99 has denied it, my lord. If your lordship will now see the evidence of PW 99.
99?
Yes, ma'am.
Who is 99?
That Jagir Khan, my.
Okay, right. All right, okay.
Paper book to कोई दिया এখন ইন্ডেক্স বানাবো দিলে না পারলে
That is there in 154.
I have given my in 9301, my lord.
154(2).
Yes, my lord.
Yeah, yes.
So I think, my lord, if I take your lordship to the evidence, my lord,
Yes,
just
read.
the main parts, my lord.
Yes.
My lord, that's 303 in my paper book and 563, my lord,
Yes.
is the paper book page. So
Mm.
just drawing your lordship attention, how your lordship will take it is one aspect, legal aspect, I'm saying. At this stage, the prosecution has prayed to declare him as a hostile, which is allowed, and prosecution is allowed to prosecute. Actually, hostile, my lord, he has to satisfy the court, the part of which he is declaring him as a hostile. So this observation should come, my lord, for future use, my lord, as I feel, my lord. I was interrogated, now the cross of the PP starts, my lord. All these things comes, my lord. Then cross-examination of R.H. Khan, my lord. Well, before that, how investigation was progressing, I'll show that. If your lordship will come to page 304, my lord, before cross-examination part, 5 line above, my lord. It is not a fact that I have made any statement before the additional district magistrate Haflong, which is marked as exhibit 335. If your lordship will see exhibit 335, which is available at page 564 of the paper book, it is a delivery challan. It is not a statement. How it was marked?
335.2.
My lord.
335.
335. If I'm not wrong, 335.
Exhibit page number?
My lord, it says 564.
Twice.
Probably it will not be correct. It is in volume 6, my lord. Exhibit 335, my lord. Page is 1398, my lord. Volume 6. Paper. Page 1398. Page 1398, my lord, exhibit 335. It's a delivery challan and not as observed by the learned trial court below, my lord?
Appears to be some kind of error.
Maybe, my lord. But what is coming, my lord, maybe, it's true, my lord. But however, because they are saying it is not a fact that I made any statement before the additional district measure Haflong, which is marked as exhibit 335. That is done anything. That's sir. Done anything 335 to bull whole baki.
Do you have any the idea about this exhibit? The 335, what has been proved is from a delivery challan, exhibit 332,
Onwards, my lord.
333, yes, it goes on like this only. And it does not, obviously it is nothing to do with this witness.
Court is of the view that it may be wrongly got marked.
Find out what is this statement which you have tried to rely upon. And then assuming there was a statement, what was contained therein? You have not put to the witness.
Only marking, mere marking of document.
Mere marking.
Is not the proof of the contents.
Otherwise also previous statement can't be.
Yes.
put in this. Yes, carry on.
My lord. Then cross-examination pass, my lord. All the bills which were exhibited by me today, white exhibit 62-148 to such and such, and are the bills which are prepared and submitted by me under my signature as secretary, Minaret Club, after receipt of the goods by the respective office circle for distribution of foodstuff, after the supplied foodstuff articles were received by the respective office. And in respect of delivery challan exhibited by me today such and such were also signed by me. After receipt of the bills by me, enclosed with the copy of the delivery challan given to me by the concerned office, I issued money receipt which are exhibited by me today as exhibit 338 and 339 after getting the required amount mentioned therein. I have not given any statement before any magistrate during investigation.
All right.
So this is also denied. So from his cross-examination, it has been clearly established no money was paid to him. Nothing was done. He has received everything and accordingly has signed it and issued the certificate. But the 161 statement was on a different note and the substantive evidence is in a different note, my lord.
Right.
So the trial court finding is that from his observation, nothing comes out, my lord. Simply just quoted the evidence, my lord, because last line, last para, here the honorable trial judge writes, after receipt of the bills by him enclosed with the copy of the delivery challan given to him by the concerned office.
There is no conclusion.
No conclusion, my lord.
Yes.
My lord, your lordship knows, my lord, there is a way of writing the judgment which has been prescribed under the code, probably it's 354 CRPC, my lord. So that is completely not followed, my lord. My lord, because the reasons
You can't declare the judgment to be illegal on that ground. No?
that line, my lord.
Yes.
Because there are a few judgments that also now be coming in, my lord, from the Honorable Supreme Court. Because while going in appeal. Shall I read, my lord?
Jumbled, yes, please.
Language and contents of the judgment. So this is the judgment chapter, my lord. What is the judgment? How it is to be delivered first? Then 354, language and contents of the judgment. Except as otherwise expressly provided by this code, every judgment referred to in section 353 shall be written in the language of the court, shall contain the points or points for determination, the decision thereon and the reasons for the decision. That reason is lacking in this case, my lord. And more specifically, your lordship will see in the C. Shall specify the offense of which and the section of the IPC or other law under which the accused is convicted and the punishment to which is sentenced. So B is the main heart of the writing of the judgment, my lord. Shall contain the points or points for determination, the decision thereon and the reasons for the decision. These two things are severely lacking in this case, my lord. This 354 is clearly hit. Because for the future days to come, my lord, I'm saying so, my lord, because
Yes. Very well.
My lord, then comes the other hostile witness, Srimati Kiran Das, my lord. She was at that time posted at Jotinga Valley ICDS Mahur and remained there till 2012. As supervisor of ICD project, her duty was to see Anganwadi centers regarding distribution of foods. The foods articles are supplied by the contractor and therefore the Anganwadi workers collect the food item from the store. While collecting the food articles, its salan is prepared where amounts of food. The name of the workers who collects the food and my signature as distribution of food. During the time, Deputy Director of Social Welfare was Muhammad R.H. Khan and she worked under him. She confirmed that exhibits such and such are the delivery challenge and all the challenge bears her signature as supervisor. Her evidence also revealed that she appeared before additional district magistrate. This also I'll take your lordship to. On 16, where she was asked some question, a statement was prepared and she has signed the statement. Exhibit 34 is the statement and exhibit 36 by 4 and one other signature. My lord, here I would like to draw your lordship attention, my lord. This lady, while taking the witness box, has said that I was taken to the court premise and I was allowed to sit in the bench. I was never taken before the magistrate. The NIA people came, gave me a document, signed it, and that has been translated into 164. That is a very sorry state of affairs, my lord. That part I'll read it, my lord, from the evidence of Kiran Das.
That is, you have expected it in cross-examination.
Yes, my lord.
Many things come out which may not be true.
No, that
Forget
is there,
about
my lord. But
In any event, it's a
I do
previous
agree. and agree,
statement
my lord.
otherwise also.
Sometimes due to ignorance, sometimes due to the pressure of cross, things comes out. But facts remain, my lord, that it is on oath now. And that part has not been resolved or re-examined, my lord. So ultimately it has become final because evidence, as your lordship knows, my lord, I need not throw light, section 3 of the evidence, that the both examination chief and cross are to be taken together and read as a whole, my lord.
That's right.
Then thereafter only it can be taken into account, my lord. So here, my lord, the lady has clearly stated, my lord, in her cross-examination court. No, it will again. There was a statement to the Bhuvi Thakur venture. For recording my statement before the additional district magistrate, how long I was taken by police. Police brought me to the office of the additional district magistrate and the police officer brought this paper white exhibit 364 and he took my signature white 364 by 1. At the time of signing of exhibit 364, I was sitting at the veranda of the office of the additional. At that time, my putting signature, I was not read over and explain the same. I did not voluntarily go there and I have not disclosed before the police to give the statement before the magistrate. I have given the statement before the additional magistrate as mentioned. I have not given the statement as mentioned before the additional magistrate. I was walking around. Why I'm throwing light, my lord. Of course, at that time, I'll respectfully submit. That time judiciary was not separated in that district. Now it is done, my lord. It's good for the society, my lord. Earlier things happen in many ways, my lord. But that is now taken care of.
Otherwise also the trial court has not drawn any adverse inference against you on the basis of this witness. There is no conclusion against the accused.
Nothing, my lord.
Why you waste the time on this?
No, my lord, sure, my lord. I'll just keep it, my lord. Normally it becomes difficult, my lord, because the evidence rounds 100 pages and nothing is said and discussed, my lord. So I thought your lordship may feel that I am escaping it, my lord. So that's why I'm bringing it. So if your lordship will see, nothing has been discussed. Nothing has been said, my lord.
There is no conclusion
from the no conclusion arrived at. No reasons or decision given, my lord, which is the heart of the writing of a judgment, my lord. And as the Supreme Court, while interpreting 354 in one judgment says, any reason that sends reason, any judgment that sends reason is not a judgment. I'll give that judgment, my lord. If your lordship wants, can look. Then coming to PW 126, my lord, paragraph 156, my lord. The evidence of PW 126, Dipolal Hosai reveals that in 2007, he contested the election and won. So far that is concerned, my lord, nothing has come out. But if your lordship will see, the observation is here. In cross-examination by the prosecution side, he admitted that during the period of governor's rule, R.S. Khan was working as the liaison officer of the council, my lord. This is completely wrong, my lord. As your lordship said, in the morning session, I agree and admit only on one count of the finding, that is finding number 1. Now that finding number 2, that whether I was working as a license, that is now coming here, my lord. I'll show your lordship that I was not working as a license officer, which the CIO PW 150 has himself said that he has not submitted any document to show that I was working as the license officer. What more? And the executive member who was examined, 23, my lord. He is also deposed that no, he was the deputy director. He was never a license officer. And in the charge sheet, it is said that I was working as the license officer, and by paying 10% in Dispur, I used to generate fund and taken into Haflong, and thereafter siphon of Rose and Fruit, and thereafter I used to pay the real Gardosa for terrorist activities. That was the charge sheet. So again, now comes to that hostile past legal evidence has been discussed, my lord, by the London Trial Court Judge 156, my lord. It is a known fact, my lord, if a witness is a hostile, my lord, his whole part will never get washed off. The part which is contradictory will get washed off, and the part that is corroborated by any other witnesses can be taken into account. That is law as it stands since the court came into existence. So I'll not go much deeper. Your lordship is well aware. But while referring this judgment, my lord, I think the London Trial Court would is applied vis-a-vis how this judgment is applicable, because merely citing of the judgment, my lord, even if we defense counsel cite it, it will not do, my lord. We must show the what is the connection of the facts, because all criminal cases are decided on facts. These are precedents are used only for the supportive values, my lord, the legal issues before the courts, my lord. So here, how this legal issue is applicable is also not discussed, my lord. Why Haradan is applied, how it is applicable in the facts of the circumstances of this case, my lord. That has not been written also, my lord. So just by stating that these are the judgments regarding hostile witness, so taking that, we take into existence that these evidence are supporting person. Because the judge right, my lord, while dealing with the 3 hostile witness, para 156(1), in the middle, after Haradan Das versus State of Bengal, so the evidence of PW 9900 and 126 so far it supports to the prosecution version relates to accused RS Khan cannot be discarded altogether. Now, where is that segregation, my lord? Nothing is there, my lord. Of all the 3 witnesses, my lord. Then we come to PW 127, para 157, my lord. So in this para, if your lordship will see that this person relates to the bank, my lord, who was dealing with the bank manager SBI Haflong Bank regarding the transaction of monetary transaction, my lord. So all these are matters of record, my lord. So I have got nothing to say, but nothing was taken also into consideration, my lord, regarding that. Just simply quoted his evidence, my lord. Then we'll come to para 158, my lord. Mukut Kamperai. That PW, probably if your lordship write it down, it is PW 128, my lord. The name somehow it got missed, my lord. PW number. PW number is 128. Mukut Kamperai was the principal secretary of NSC.
Yes.
At the relevant time, his evidence has been discussed already in previous paragraph in respect of other accused. But from the standpoint of the present set of accused, the same bears immense importance, and therefore the same is retreated again. According to this witness, he gave reply to some queries of NIA about some forms, Ma trading such, which were issued on such, under such, Devasis Bhattacharya, son of late Sujit Lowarza. The registration of the same was departmental and there was no contact number. All permits were valid up till 31/3/2008 and not further renewed. Exhibit 394 is the state letter. The registration of the contractor was done in PWD department, and his office used to issue only permit, and hence registration number is not available with him. Cross-examination of this witness by accused Devashish Bhattacharya revealed that all the forms were genuine and registered as per rule of the NC Hill Autonomous. So on the other hand, prosecution was once trying to show through the postmaster that these are not genuine or fictitious form, which completely overrules through this witness's deposition, my lord. I read, my lord, that postman's evidence, my lord, by writing the letters for service of by the postman has not PW 41 evidence, my lord.
Yes.
Gets washed away by this deposition, my lord. Then PW 74 is one Hammond Das. He is the SI of Task Force Ulubari. His evidence revealed that he made an inquiry and verified the address of Baral Enterprise Factory at Ulubari, Lokna Trading Factory at Poltamazar. He made inquiry but could not find the existence of the said two forms on 8th. He submitted his report and such is the signature. Nothing tangible could be elicited in the cross-examination witness to discredit. My lord, this forms related to the supplier and the contractor Devashish Bhattacharjee, my lord. How will I and why should I do, my lord? Because it is his knowledge, why he has shifted office, why he has not done this, why he has not done that. So it will, when the argument of Devashish Bhattacharjee will be advanced, my lord, I think they will deal with this matter. So for Aris Khan is concerned, he has got nothing to do with the where they stand, how they stand. I get the approved list from the council, my lord, and on the basis of that approved list, my lord, the office prepares the supply orders, my lord. Then comes to PW 41, Horipoddha Burman. I have already read it, my lord. It is also disclosed the previous paragraph of this judgment that is regarding the non-traceable and address and the returns of the letter. It is elicited in cross-examination that some of the letters been, this I have already done.
You already discussed.
Yeah, yeah, my lord. Now we'll come to 160, my lord. Para 160.
Again, Haripaga Burman only.
Yes,
Is dealing with this same witness.
yes, my lord. Same witness, my lord.
Yes.
Mm.
General manager BSNL.
No, 81, 41, 41. Episode 930 letters, then 137. No, I want to show, my lord, that your lordship always asks about the finding, my lord. The finding regarding this fictitious, my lord. This shows that the self-help groups are fictitious and the same is the position in respect of the farms of Devashish Bhattacharjee, which is not correct, my lord. It is to be mentioned here that the self-help group have shown to have received material on social welfare department and the farm of Devashish Bhattacharjee supplied material to social welfare and also to PHA department. So Devashish supplies the material and we in turn give it to the beneficiaries, my lord. Only one beneficiary has been examined in this case, my lord. What debarred the NIA, my lord, to examine the beneficiaries, my lord, because they are the actual person whom to be deprived. And if anybody's hunger is deprived, my lord, anybody's meal is taken away, my lord, the person will definitely speak the truth, my lord. My lord, that thing, I don't know why the NIA has not investigated. They could have easily investigated that aspect also, my lord, that whether the beneficiaries has actually received or not.
Right.
So that part is also inherently lacking, my lord. So now coming to the PW 137, Swetendra Kumar Deka. He is from a BSNL regarding the CDR analysis of other, my lord. This phone does not belong to me, my lord.
Okay.
Nothing to do with me, my lord. Then, of course, PW 141, that Nampui Secretary, not Kasar Hill. This is a Caesar witness of the hard disk, my lord, which was taken into commission, and there is a conflict between the Caesar made by through PW 25 and through him. He says that it was seized when it was produced by Firenica, and Firenica, the person who on oath has deposed, no, I have not given it. It was the NIA who was sitting in the circuit house. They have prepared a list and given it. So whose evidence will be tested now, my lord? So when two views are possible, my lord, definitely favorable to the accused will be taken. PW 41, my lord, is that Nampui Secretary, not Kasar Hill Autonomous Council. She was working as election officer on such and such. Then she says, my lord, on the last part, in the cross-section, she admitted that she did not herself physically counted the GA pipes and all these things. the defense side made an operative attempt to cast a doubt upon the evidence of witness, referring to the evidence of PW 25. It is in page 153, madam. It is an admitted fact that both the hard disks have been separately wrapped by paper bearing details of the case and signed by the witness. But the facts remain that after such seizure, oh no, sorry, I missed a line. And in the court, PW 141 has not seen her signature and also the signature of the witness because the contents was removed, my lord. But the facts remain that after such seizure, both the hard disks were subject to examination of expert, and this will explain why the signature of the witnesses are not there. It is not the case that the hard disk was produced before the court in same condition as it was at the time of seizure. The evidence of this witness withstands the acid test successfully. She is a responsible government officer at the level of a secretary. Her evidence stands in higher pedestal than PW 21, which evidence have already been discussed, and who faithfully obliged to all the suggestion of the accused and goes to the extent of giving a certificate that R.S. Khan has no connection with DSD and he is a capable and sincere officer and has discharged his duty smoothly and properly during his service period as Deputy Director of Social Welfare, Haflong, ignoring her position. So just because she is a junior level officer, she should not be believed. And the person who has deposed in favor of Nia is a superior officer, so she should be believed. That respectfully, I'll respectfully submit that cannot be. What is the legal test, my lord? From whom seized is the base person, and it was PW 25. It is said by Nia that she has given and I have seized and she has put the signature. Then that is not coming, my lord, from her own mouth. The person who are the signatory to it, they have been cited as seizure witness in the charge sheet, not examined in the court. If I say it other way, that they have, Nia has brought in the evidence of 151 by saying this wrong facts, my lord. It may be read it that way also vis-a-vis 25. But it is coming from the horse's mouth, my lord. That is my respectful submission, my lord. The best evidence has come true. Now the handwriting expert is one PW 144 Amal Chandra Kolita. This handwriting expert's opinion was not taken into account. One positive thing that has been done by the trial court, because the reasons for opinion was not given by him. So mere submitting of opinion is of no value. So that's why the reasons for, due to non-submission of the reasons for opinion of the handwriting expert. So that part of the evidence was not taken into consideration. Right? 13 now. It's already in our favor. 193, 162, para 13, my lord. The learned defense was said that admittedly PW 144 has not submitted reasons for opinion on what basis he formed the opinion. According to him, expert opinion without reasons cannot be.
14.
Yes, my lord. The learned defense counsel referred to Krishna Kantadava State of Assam and Haji Muhammad Ikramul versus AS Assessor in supportive submission. So this being the factual and legal position, we record the concurrence with the submission so made by the learned counsel in respect of the expert evidence. Then comes the evidence of the IO, my lord. PW 147 Sanjay Kumar Malviya reveals that he did part investigation of the case by Exhibit 39. He collected 5 documents. Exhibit 39 by 5 is the Assam Financial Rule. Exhibit 435 is the receipt memo issued by the JIT Enterprise. Exhibit 374, 375 are the 6 numbers of check. So now the main IO of the case, my lord, nothing has been discussed. And why it is not done, I'd like to throw light on it. Because this main IO, he never visited Haflong during the course of the investigation. He only sat in Guwahati. Now, these 2 persons who were sent and deputed to Haflong say on behalf of him on his recommendation, though legally not admissible. But in a NIA Act, there is a rider, my lord, that who can investigate it. It is only the DSP who is only to investigate the matter. And they were all sub-inspectors, my lord. No? Inspector, my lord.
But there are judgments on PCA.
Well,
That
17,
this
section
will not-
17.
This will not vitiate the person.
Wow.
Similar.
That H.N. Risbah's case, my lord.
Exactly.
I'm aware, I know, I told him last night that this will definitely come from your lordship, my lord. H.N. Risbah's case is that I must show prejudice. I must show that something
Precisely.
which is not entitled. But what I submit, my lord, that these being a very vulnerable cases, my lord, probably we cannot equate it with the PC Act cases. Why I say so? Because these are the specific guidelines that you need expert hand. Because of all these non-expert hands, the case will get damaged and the accused may be falsely also implicated. So that's why these guidelines has been strictly followed there, my lord. It is not that I have to show prejudice in every area. You have to do everything in the manner as it is prescribed. Because it is a near act, it's a federal act, my lord. Everybody in everywhere it is to be followed, my lord. So the strict compliance is also necessary in some cases, my lord. It is like in NDPS cases, my lord, that the recovery proceeding, my lord. Strict compliance is necessary, section 50, my lord.
Right.
Otherwise, the whole case of prosecution will fall flat if it is not in accordance with section 50. Likewise, also I submit, my lord, in this case, though of course prejudice is to be shown, the judgment saying, but the act says that it should be done not less than by the DSP. So it is ought to have been
Little
done in the
debatable,
manner-
debatable kind of thing.
My lord.
There's no absolute proposition
My
that the investigation by an unauthorized officer would vitiate the trial.
Yeah, trial,
It's
my
not so.
That is one way of looking at it. And the most important thing, my lord, the CIO, my lord, who is the architect of this case, my lord, he does not with the social welfare office, he doesn't do anything. on-
Argument, yes, we will,
My-
when we read the evidence,
Yes, my lord.
we'll of course, right, yes.
So, so that's why nothing regarding the investigation part has been taken into account while writing the judgment with all respect. So more particularly the CIO, now regarding that part, my lord, say that postman part, what he will show like, my lord? During investigation, he did not go there. He sat all the time in the Guwahati city, my lord. That hill area he ought to have visited, he see the things, draw the sketch map and all the things, my lord. All these things were never done. Now, my lord, so far, these are the evidence concern, which I would not like to take in details. Your lordship has already got it. But what I will try to say, there are certain 3-4 legal aspects how to look into. The sanction aspect is one aspect, my lord, which we have.
Sanction to prosecute.
Yes, my lord. That I will deal with subsequently, my lord.
Yes.
But that is the FIR part I have dealt with, my lord, that it was not properly written. And that GD entry, which is the main foundation of the case. And it was not a cryptic information. Because the GD entries evidence says, my lord, through PW2, my lord, I believe, that they have recorded that GD entry says that we have received information that some party is going to come today in two vehicle, and they will be carrying cash to buy arms and ammunition for terrorizing people. So that itself discloses the ingredients of section 154.
That is an apprehension. That's
Yes,
not-
no, that is, no, if I read the evidence, my lord, I will stand corrected, my lord, if it's so. But the law says that if it is cryptic, not disclosing any offense.
The issue is, by that time, there was no recovery, it was an anticipation. Whether the FIR could have been registered on anticipation.
No, not anticipation, that GD entry book or that GD entry.
That
extract
should
would
have
be
been
very
produced.
well
That's-
brought into it.
yeah, That's right, that's right.
I
That
have
argument
also
is-
got nothing to say
But the
regarding
FIR
it
will
because-
not be hit by that.
because I am not a,
You could have requested the court to summon it.
yes, my lord.
Did you file any application?
My lord, we would like to see the prosecution goes into the defective field, my lord. It was the duty of the prosecution to brought it on record.
All right.
CW could have been also brought in, my lord, court witnesses could have also been brought in
Yes.
to prove that aspect. But that aspect was never brought in. Why I am showing, because that was the foundation of this case.
Secret information.
Yes,
you are
my lord.
referring to, yes.
But they have reduced it in writing, my lord. That reducing into writing which disclosing a commission of a cognizable offense as per section 154, it ought to have been taken
It's
into
not,
account. my lord.
it's not any information at par with 42 of the NDPS Act.
Yes, my lord,
Yes,
absolutely.
all right. It was just a measure to give them the impetus to initiate the proceeding. That's all, nothing more than.
And
Well, we'll see,
furthermore, I am
we'll
pointing it out for further reference also in the future so that this mistake doesn't take place, my lord. We as a citizen also have to look into that aspect.
Yes.
So I'm just reading the evidence, my lord, regarding that PW2, my lord, he has said. I was posted at Bokisto police station from March 2009 as officer in charge. On 1/4/2009, I was working in the, I was working, I was working as officer in charge of Bokista PS. On that day, additional SP headquarters, Sudhakar Singh and additional SP R. Raswa came to our police station and reported that some members of DSD group are going to deliver money to the extremist group at Jorabad area. After getting the information, I deputed SI Mojiddin Ahmed to go to Jorabad to inquire about the information. Mojiddin Ahmed came to the and said. And furthermore, in the cross, I'll just go from my cross mile, I'll show. You don't have to PW. নোটিং করা আছে The information received by SI Saikia on 3509 was recorded in the general diary, but that general diary is not before the court today.
You're reading statement.
Yes,
of-
but I'm reading from the deposition of PW2, who was the Oshi Bokista PS and who registered the FIR, my lord.
Chandrakant.
Yes, my lord.
Chandrakant Bodo.
Yes, my lord. Sandra Kantra Boru, my lord.
So where are you reading, by the way?
I'm reading from page 1 itself of my paper book, your lordship will see at page 4, my lord.
Yes.
As per Assam Police Manual, a case diary of a case is opened immediately after the affair is registered and the case is referred to the IO for investigation. In the instant case also, the said procedure was followed as regards to the opening of the case diary. A special diary is opened by police and certain special purpose, but once the FIR is registered and the main CD is opened, SCD is thereby closed and all further investigation made thereafter registered or entered in the main. It's written as main CD. I have opened the SCD on this case on 35. I have closed the SCD on that day. Bikul Soikia informed me over telephone from Haflong that one RS Khan is required to be
This is
interrogated.
subsequent to the registration of the FIR.
My lord, this is regarding the, my lord, then
Regarding-
that part your lordship will find it, my lord.
On
GD
top,
entry,
Babul Kemprai. Babul Kemprai
Yes.
cross.
in the examination in chief itself, it is coming that they were aware that Sudhakar Singh, that some members of DSD group are going to deliver
They
money
did not.
to the
they-
extremist group at
Yes,
Jorabad
yes.
area.
So that was a secret information.
No, but that is made it translated into 1164 GD matter.
Where is it referred that they have written it? Where is it mentioned that they
No,
have
in the FIR
recorded?
itself, no, my lord, in the FIR itself,
Hmm.
they makes a reference on the top, my lord. This FIR is of Bokisto because Bokisto PS was
So
taken.
that you are
1 year.
now talking about is the entry pertaining to the departure of Moizuddin Ahmed?
No, no, no,
What
no, no,
proceeding?
no,
There-
no, no, my lord, no, my lord. Let us come to page 3 or the original as your lordship has seen at page 61. Page 3 is the photostat copy marked as exhibit, but on cross examination, they subsequent.
GD entry number 1162.
Yes, my lord. 1162 in the top of 5. Bokisto PS GD number such. Now, if we come to the evidence of PW2 at page 16, my lord. My running page will be
Yes, yes.
page 2, my lord. On 1/4, I was the OC Bokisto PS. I made a GD entry number 1162 dated 49 as referred in the FIR. Before handing over the case diary to Nia, it was in my possession. That is up till 1/6/2009. After 2 months, the case was given. I have not given any instruction Moizuddin, but verbally told him to do the legal work as per information received by GD entry number such and such. 1/4 time was made on the information received from Sudhakar Singh additional. So my respectful submission, my lord, from here is that neither the extra copy of the GD is also enclosed with the record. What I'm trying to say from the legal connotation, my lord, that the GD entry is actually the FIR, my lord. Nothing for RS Khan as such, my lord. It is regarding the extremist
It
workplace.
was not the FIR, it was the secret information which they recorded. Then Maizuddin Ahmad must have been sent on the basis of that
Yes,
secret
absolutely,
information.
absolutely correct.
So it
Was
is,
sent.
it is not, it is an anticipation that a secret information is received and you are required to proceed.
So-
Just same like 42 1 in the NDPS Act, information regarding concealment. So there is a mandate that it
Mandate.
must be recorded
Yes.
and forwarded to the
It's not
superior
mandate.
officer.
It is
But
just a
yes, you are
procedure.
right. The recording of the information in the diary, that is what we call it Rosamcha.
Yes.
So dispatch and the exit of Moizuddin Ahmad.
Absolutely.
On what basis?
He
That
left
was
the-
a very vital document.
Right, my lord.
And there are Supreme Court judgments to the effect
Yes, yes.
that in some cases, that Rosamcha entry whereby the officer proceeds.
Yes.
That is very material. They'll have to show
Your lordship
why they
always-
didn't produce.
your lordship
Because in
always
the
has
statement, itself, it is coming out
Yes.
that the court waited that the diary is to be produced.
Yes.
Then what happened?
Correct, my lord.
Read at page 2 of this very witness. Second page.
Second
Cross for general diary is not before the court today. Deferred due to non-availability. of
Due to
certain-
non-available certain.
So it was not called as per you. The diary was not received then.
No, but still it went on, my lord, because
don't know.
this
We
date is
suppose.
27
Just-
two.
Just hold on.
Yes, ma'am.
We feel that the diary was produced. Read cross for JK Ghosh.
Yes, my lord.
They are referring to this entry.
It is incorrect to suggest that the entry dated 1/4/2009 in the general diary of the Bokista Police regarding Bokisto PSGD 116 dated remand recorded as is 6 AM is a false entry.
So the entry was there before the court. It may not have been exhibited, but the entry was there.
I don't think so, my lord, because why I say lordship has rightly pointed out page 2, at this stage further cross is deferred due to non-ability of certain documents. Probably these certain documents is all the thing is dealt with is the GD. Now,
That's why we are saying next page, sir.
yes, yes.
Cross for accused JK Ghosh.
I'll show your lordship the date. This date pertains to 1/9/2012 and this date pertains to 27/2/2013, my lord. That is
Yes.
after a year,
Yes.
after 7 months.
Yes, yes.
Yes,
But
ma'am.
read the cross for JK Ghosh. please.
JK goes. It is incorrect to suggest. This is a suggestion put, my lord.
On the
Dated
basis of the reference to the GD.
GD entry. My lord,
Yes.
because this GD entry was made in the morning at 6.
When Sudhakar Rao
Yes,
arrived.
came and
So
gave
that is
the
what the GD entry is. There is no other GD entry.
That was the GD entry.
So that entry has come in the court. That's what we are saying.
No, I don't think so, my lord.
Read, please. Otherwise, how could the council have asked about the time?
No time because it is mentioned in the evidence, my lord. It is mentioned, I read it, my lord. I'll just show it. Asking nice was in time. I think it was written 10 PM. Close. No, my lord, date is not there. But I'll find it somewhere, my lord.
Yes. Come to the bottom of this very cross examination. On behalf of JK Ghosh, last para,
I'm coming. my lord.
page 17. I have not come with the GD of Basista Police Station even today.
Well, to be fair enough, I'll point it out. One thing, probably your lordship is right. But legally, it was the copy produced. I'm
Yes,
getting
it was
from-
copy
Yes,
produced
absolutely. I put.
from the case that
I stand corrected, my lord. Here in this case, the prosecution side has not exhibited the Bokisto PSGD number 1162 in the court. But a copy of the same is available on the
that
record.
is the finding of the trial court.
Yes, my lord.
Yes,
Observation.
that is available now. If you see this cross of JK Ghosh, last para, that will be clear.
I'll read for your lordship.
Read from PW2,
Yes, my lord.
page 17. Cross for JK Ghosh, last para.
Last para. The GD entry, I have marked it. GD entry number Iman as referred in the FIR mentioned by me in my examination chief and thereafter in cross examination is an entry which I have made in a
I
general.
have come with the general diary of police
Yes.
station.
I have
This is
made in
even
the
today.
general diary. I do not know Santosh Kumar Singh. I have no personal knowledge regarding. My lord,
Above
page
that,
17.
above that, I have not come with the general diary of
Ah,
Basista Police Station.
Even today. I have forgotten whether I have gave it a section 161 statement to NIA with regard to this case. I was the officer in charge of PGS when the NIA took over from the engineer. I continued to the officer in charge till October 2009. But that copy, though it is written in the judgment fairly pointing it out, my lord, but it was,
Original was not produced.
my original was not produced, and how it came into the record is also not there, my lord. I'll read because you're
On
what,
top of this witness, this cross examination, he produced the case diary in which there were some loose sheets.
maybe,
And
Lucian,
that is the copy which probably
probably,
is a part of the record.
But that
It
aspect,
was not exhibited
yes,
because it is a copy.
yes, the copy has been taken into, how much it can be looked into is one aspect.
Yes.
But it has been said that it has fulfilled the requirement 154 CRPC. With all four, it would be an FIR here in this case.
All right. Okay.
Then, my lord, from the evidence which I would like now to throw light, which are appearing in favor of the accused, my lord, were not taken into considerations, my lord. So I will be dealing it today or Monday, my lord.
Whenever, as per your convenience.
No, my lord, your lordship, I can go, my lord, because once we prepare it, we can definitely go. But since I'll be opening a new vista, so that's why I said
All right, do it on Monday.
Monday, my lord. The positive evidence that appears in the court's record.
Hearing continues. On Monday.